Good morning, Mr. Kennedy. Good morning, everybody.
Good morning, Chair.
Are we ready?
Yes, we are.
Okay, let's continue. Mr.
Morning, Chair.
Ntshepe, good morning.
Good morning, Chair.
The oath you took yesterday will continue to apply today, you understand?
Yes.
Okay, all right.
Good morning, Mr. Ntshepe.
Morning, SC.
May I ask you to return to a document we were looking at yesterday? It is in Bundle 1, the Nell Bundle 1. And if I may ask you please to turn to page 824. You recall this is the motivation that was sent to Mr. Mlambo for his approval as group supply chain executive of the single supplier contract between DLS and VR Laser. We looked at this yesterday, remember?
Correct.
And Ms. Malashlela indicated at page 824 that the reason for the request was that there was a Denel supply chain policy which required that approval be obtained from the head of supply chain for a deviation of the normal rule, which was that such contracts should be kept in-house for an inside supplier, inside Denel, unless there were good business reasons to go outside. And she indicated that she was instructed to request this, and Mr. Mlambo refused to give that approval, at least at that stage. He said what would be needed was that there would have to be proof that the internal entities, DVS and LMT, could not meet the requirements. Now, you remember you gave evidence yesterday that you overruled Mr. Mlambo's decision.
Correct.
Were you aware that DVS and LMT did not submit proof to Mr. Mlambo that they could not satisfy the requirements?
I was not aware of that.
Yes. In fact, the evidence is that no such proof was submitted, and yet you approved the transaction.
Correct.
Now, I said to you last night when we adjourned that yesterday evening that we would now give you an opportunity this morning to explain why you overruled Mr. Mlambo.
Thank you, SC. Thank you, Chair. I think the facts are there for themselves to prove that the Denel has always been late and sometimes being very bad penalties in terms of deliveries because their programs were late or the programs did not meet the specifications of the client. When Mr. Mlambo, when this motivation came to me, it came to me after they had taken to Mr. Mlambo and Mr. Mlambo did not approve. And to me, what was urgent was for the work to be done, not for people to, if Mr. Mlambo really wanted to find out to exactly why is DVS and LMT not submit any proof that they cannot do this work, I think it was upon him to go and find that information out. In other words, I'm saying that it could have been a mutual responsibility between DVS and LMT. Now, for me, what was, as the memorandum is explaining, that this was an urgent request, which this vehicle was prepared for a demonstration. And the parts that were going to be used were specialized fabrication parts, which Via Laser at that point in time was the company that we knew that were able to do that. So when this request came to me, it came to me on an urgent basis to say that we really need this thing, otherwise we will not be able to have this vehicle for demonstration. So I approved it based on that. And further to note that Mr. Mambo claims that I scratched his name out in this document, which is false. I did not scratch his name out. So I believe that I took the right decision to approve it. And also to further explain that, you know, Denel, though is a state-owned entity, it's an enterprise which competes with private enterprises. If you are not able to deliver a product at a certain point in time, you will pay the penalty, either financially or by losing the sale, or by losing the opportunity to demonstrate your capabilities. So those were the things that were motivated me to overrule him. Not to say that I undermined him, I did not undermine him, but for me, it was for the best interest of the company to make sure that we are able to do this on time, and we do not have much time to be dilly-dallying and being given the label that Denel cannot deliver because in the marketplace, as you have indicated also, I see that Denel was late 11 years on some products or on a project which should have been delivered 11 years ago.
May I just unpack a few of the points that you've raised, Mr. Ntshepe? You're aware, are you not, that the agreement, the MOA, had already been signed before Mr. Mambo was asked for this approval?
Yes, I was aware.
And you had been involved in that signature?
Yes, I was, as a witness.
Now, as I understand it, one of your reasons was, in fact, well, the memorandum of agreement has already been signed, and so we can't cancel it now, even if Mr. Mambo is advising us to, based on procurement requirements, because the horse is already out of the stable.
Correct.
The agreement has already been signed. You're already committed to VR laser.
Correct.
Yes. But how did it come about that an agreement was signed before the person most senior in the organization responsible directly for supply chain management, Mr. Mambo, had never been asked for his approval, which was required under the procurement policy?
The agreement was signed as per the instruction of the then CEO, the erstwhile CEO, Mr. Saluji. And the people who were involved in it were the executives. As I have indicated before, Mr. Mambo, although he called himself an executive, he was not an executive. He was a senior manager, group senior manager, supply chain. The executive was the CFO. He was reporting to the CFO. In terms of the titles in Denel, I think there is a blur, because if you are invited as a permanent invitee at ESCO, it does not necessarily mean that you are an executive.
Well, let's leave aside for a moment the question of whether his title was truly executive or truly manager. What I'm particularly interested in is that you had a situation where you signed an MOA where the procurement policy required approval from the supply chain manager, in your language, Mr. Mambo, because VR Laser was not a Denel subsidiary, correct?
Correct.
Were you aware of that requirement at the time that you signed it, the MOA?
That VR Laser is not a Denel subsidiary.
Were you aware that there was a requirement in the procurement policy that where goods were being bought from an entity outside Denel, that there had to be a good business reason for going outside the divisions of Denel or its subsidiaries, and that good business reason had to be approved by the supply chain manager. Were you aware that the procurement policy required that?
As a group business development at that point in time, I would not have been very familiar with all policies of the organization. I will be familiar in particular with policies that are pertaining to business development. However, the signature, why Mr. Mlambo's signature was not in the MOA, it was the prerogative of the erstwhile group CEO.
Sorry, the prerogative of?
Mr. Saluji.
Mr. Saluji.
Yes.
But won't you answer my question, please? I appreciate that as the executive dealing with business development, you may not have known everything in the organization. My question was not whether you knew everything in the organization. My question was specific, and may I ask you please to give a specific direct answer, specifically in relation to the requirement of the procurement policy of Denel, that if you were going to buy goods from outside company divisions or entities, you would need to have a good business case, and that had to be approved by Mr. Mlambo. Were you aware of that rule?
I was aware of the rule that if you were procuring services from outside, you will have to have the processes in order for the approval. The final approval, whether it was Mr. Mlambo or the division head, I was not aware. I was not totally aware of that.
Well, it is true that the chief executive had authority to sign such a contract. That is true. It is also true that the chief executive was the chief of the administration, so that Mr. Mlambo was subordinate to Mr. Saluji in terms of power and authority. All of that is true. But you will see on this page, 824, that Ms. Malashlela has taken the trouble to quote from the supply chain policy the provision in question. And it says, and here the supply chain policy itself uses the term supply chain executive, but leave that aside, that it has to be approved by the group supply chain executive based on sound business reasons. So apart from the fact that the group CEO would, at the end of the process of recommendations and evaluation and all of that, sign the actual MOA, before it could get to the CEO, there had to be approval by the supply chain executive or manager. And you were aware of that rule, not so?
Yes, I was.
Yes. So are you saying that this fell away simply because Mr. Saluji was prepared to sign the MOA?
I think in my affidavit, I had explained the relationship that had now evolved between Via Laser and Denel in terms of the relationships, in terms of the MOA.
Yes, but I'm not talking about relationships with VR Laser.
Yes,
I'm talking about compliance with the Denel policy within Denel.
Yes.
Maybe before you answer Mr. Kennedy's question, and please don't forget it, Mr. Kennedy, do you agree that this rule or policy, as quoted in Ms. Malahlela's memo, actually prohibits the procuring of products or services from outside of Denel when there is a group entity or division within from which such product or services can be obtained, unless there are sound business reasons? Do you accept that?
Yeah,
You accept that?
Yes, I accept it.
Okay, all right. Mr. Kennedy's question then is, are you saying that this policy or this rule fell away in this case?
I believe it did, because the motivation was to say that after an EXCO meeting, they had agreed on an exception that they should procure these services.
Mr. Kennedy?
Thank you. In this case, of course, there was no open procurement process, correct?
Correct.
as there had been, at least in the sense of 3 quotations were sought for the platform hulls contract that went before, correct?
Correct, as per the memorandum.
So there was no competitive process for the single supplier contract, and there was no good business reason that was approved by Mr. Mlambo, correct?
Correct.
Yes. There is nothing that I have seen in the group procurement policy that says that if the supply chain executive or manager refuses approval based on good business reasons, if he or she is not satisfied, that the CEO then has the power to override him or her. Are you aware of any such provision?
There is no policy like that, but at the same time, I am totally responsible to the board, not Mr. Mlambo.
And 1 second, Mr. Kennedy, I may have caused some slight confusion on the meaning of the rule. This rule here, as I read it, I think I may have put it slightly differently. It seems to prohibit the procuring of products or services from outside of Denel when there's a division or group entity within that can provide such a product or services unless there is approval by the group supply chain executive. So it seems that it is a condition that the approval of this particular specific person or incumbent is obtained. And the sound business reasons, it seems, are sound business reasons for him approving that you go outside. I may be wrong, but you are free to indicate your own understanding. It seems to me that what the rule says is he is the one who will approve or not approve the procuring of products or services from outside if there is a division or group entity which can provide the same product or services. But when he approves, in those circumstances where he approves that services or such a product or services be obtained from outside, he must have sound business reasons. So he's the one who must have sound business reasons if he's going to approve that such product or services be obtained from outside, not somebody else. Do you share the same understanding?
Chair, I share the same understanding with limitations in the sense that the ultimate responsibility of the organization lies with the CEO. If there are things that are not done in the company, I cannot go to the board and say so-and-so refused to do that. Or then the question will be, why didn't you put him through a disciplinary? Which I'm not sure if Mr. Mlambo works for Denel now or not. But I believed that I needed to expedite the work of Denel and be able to have this demo ready on time, because this is a demo vehicle. I think it was going to be shipped. And there are limitations in terms of time where the ship and where it was going to be shipped to. It's a long way, if I still believe. This was probably Pakistan, because it's a T5. If you delay the process, then it's either the vehicle will not go and we will therefore not be able to demonstrate, or and then we will lose the opportunity for other clients in the world to see what type of capability we have.
Mr. Kennedy, I know I interrupted you, but I thought I may have given a a different understanding of this rule. But maybe even the meaning that I've given might not be 100%. I don't know what, but you can go according to how you understand it.
Chair, with respect, we're comfortable with the proposition that you have put to the witness, Chair. So, but if I may just develop the questions that arise from that.
Yeah.
Are you saying, Mr. Ntshepe, that because it was urgent, that gave you the right to deviate from procurement policy?
I'm saying that there was a motivation. To me, the motivation made sense. And we had also the agency of doing making sure that the vehicle is ready. Therefore, with the responsibility that I bear on my shoulders, that gave me the right to be able to do that. And the authority to do that.
So, where did you get that right from? From the fact that it was urgent and you needed to report to the board on the progress. Is that what you're saying?
It was urgent, and secondly, that I cannot have an excuse that we could not demonstrate because Mr. Mambo delayed the process.
Yes, but what I'm suggesting to you is this, that even if it was urgent, you still have to comply with the law, not so.
Yes, in my view, I complied with the law. I might not have complied with Mr. Mambo.
With he?
With Mr. Mambo.
With Mr. Mambo.
Yeah.
And we've just seen the procurement policy provision that says that Mr. Mambo's approval had to be obtained for this, going outside Denel's operations. He had to do that only if he was satisfied that there was a good business reason. Now, you saying that where Mr. Mambo decides that there's not evidence before him to show a good business reason, so he doesn't approve it, that therefore you could override his decision because it was urgent.
To me, Chair, that was not reasonable for him to do that.
Just repeat that.
To me, Chair, that was not reasonable for him to do that because he knew exactly what the consequences thereof will be in the event that we do not complete this.
But Mr. Mambo has given evidence, and I'd like you to comment on it. He was saying that his job included the responsibility of enforcing this as well as other provisions of the supply chain management policy. He took it seriously. He wasn't even asked for his approval before the MOA was signed. Are you aware of that, and do you dispute that?
I will not comment because I was not the one who put the MOA together. And the person who signed the final signature is the one who decided who should be consulted or not.
Yes, I understand that you may not have had active involvement in the MOA at that stage, but you're aware of it now, not so. Were you not aware of it at the time that you saw this memorandum and actually signed to have it approved? You see, page 824 actually makes it clear that the MOA has already been signed. If you look at the second last paragraph on page 824, it says in the second line, in May 2015, DLS signed an MOA with VR Laser for this scope of work.
Correct.
And then Ms. Malashlela says the last paragraph, due to these contradicting positions, supply chain approached DLS Exco to make a decision as to whether to honour the MOA and place the order on VR Laser or to follow the supply chain policy and procure from intergroup, namely DVS or LMT, for this project. Given the time frame, urgency and history, Exco has recommended that the work be done by VR Laser. So Ms. Malashlela makes it clear in this memorandum that you signed to give approval, she makes it clear that what is now being sought, what is now being requested from Mr. Mambo is approval retrospectively, after the fact, because the MOA has already been signed, not so.
Correct.
So I get back to my question. What do you say about the fact that the MOA was signed at a time in May 2015 when Mr. Mambo had not even been asked whether or not he wants to give his approval?
I repeat again, SC. that the MOA, the individual or the actual GCEO is the one who decided who should be involved in signing the MOA. I cannot create something that I have no idea of why he did not do that. I can speculate, and saying, yes, now I understand, but he did not do it. The fact is, he did not do it.
So you were not aware at the time that the MOA was signed that this had not been done?
No, I was not.
Is that correct?
What is this? Sorry.
I mean, at the time when he read this memo?
No, I asked Chair, the witness, was he aware at the time that the MOA was signed that Mr. Mlambo had not given his approval? At that time?
I was not aware of that.
You were not aware, I understand that. But now you then become aware because you're asked to override Mr. Mlambo's refusal. You're aware by way of this memo of 29th of October 2015. So that's more than 5 months since the MOA had already been signed. You're aware now, as Group CEO, that people in the organization had signed an MOA without following the procurement policy provision specifically requiring Mr. Mlambo to give his approval. And now what she is trying to do, Ms. Malashlela, instructed by her DLS board, is to get Mr. Mlambo retrospectively to authorize the deviation. Is that correct?
Correct. But
Yeah.
with due respect, can I continue?
Sorry?
With due respect, Chair, 5 months after the MOA has been signed, the group chief, procurement is not aware. There is tardiness somewhere there.
There's what tardiness somewhere, did you say? What did you say? I didn't hear you. Did
Tardiness. In other words, there's neglect of responsibility. After 5 months, it has been signed. And Ms. Malashlela was responsible for the supply chain in the division, whereas his boss is not aware of that. 5 months. To me, there is tardiness. There's neglect of responsibilities.
Yes. There's a neglect of responsibility.
Yes.
Are you blamed? Sorry,
On whose part?
Both, especially Ms. Malashlela, because if she knew that because she's the one who's writing that the MOA has been signed, she should have informed. There was group meetings of the supply chain at Denel, like there were group meetings of the business development. Ms. Malashlela should have made sure 5 months that his boss is not aware. I don't know what they were discussing then in the group supply chain meetings.
Mr. Kennedy.
Thank you, Chair. Isn't it a bit unfair of you to be pointing the finger of blame at Ms. Malashlela? She's already given evidence to this commission in public on TV that she in fact specifically recommended to her board at DLS and her EXCO that there were breaches of the procurement policy and it should not go ahead. And in fact, as I pointed out to you, her evidence has been that she specifically used the words, for example, I hereby request permission to implement the EXCO decision because she disagreed with that decision. Isn't it a bit unfair to blame the person who was in fact strongly recommending to management that they shouldn't sign the MOA, that it was signed without the necessary approval being obtained?
Chair, Honorable SC asked me if Mr. Mlambo was he aware of that the MOA was signed 5 months thereafter in October, meaning that it was signed 5 months before October, the MOA, and he was not aware of it.
So are you blaming not Ms. Malashlela and you're now blaming Mr. Mlambo?
No,
or
I'm
are you
not
blaming both?
Sorry, SC.
Yes, let's give Mr. Ntshepe a chance to answer.
I'm not blaming Mr. Mlambo. I am saying there is a relegation of responsibility here, whereas there were individuals who were holding meetings almost every 2 weeks, I remember, in the group supply chain at head office. And this matter should have been discussed there. And I am acting only on the document that is laid before me.
Yes. Yes.
Do you remember, Mr. Kennedy, whether Ms. Malashlela indicated whether how she became aware that the MOU or MOA had been signed. I know that with regard to Mr. Mambo, one got the impression that there was an attempt to ensure that this didn't come to his attention or something. At least one got that impression. I don't know whether you got the same impression. Now, yes. I don't know, I can't remember Ms. Malahlela's evidence as to when she would have become aware of the fact that MOA or MOU in May had been signed.
Yes, as I recall the evidence, she was resisting the signature from the outset of the process and was then aware that she was being overridden. So it wasn't as if she found out only after the event.
Yes.
Whereas Mr. Mlambo did in fact he was only asked for this approval 5 months after the MOA had been signed already.
Yeah. Yeah, no, that's fine. Well, one of the questions which I think Mr. Kennedy had asked at some stage, Mr. Ntshepe, which I would like you to deal with, because I'm not sure that you dealt with it properly, is I understood Mr. Kennedy to want to find out what your attitude was when you became aware that Mr. Mlambo's approval had not been obtained before the MOA was signed. When you discovered that which at the latest, I guess, would have been when you signed the approval when he had refused. In other words, when you realized that there had been no compliance with policy, what was your attitude to that?
My attitude, Chair, was that because of the nature of the request, there was an agency to go ahead, and that's why I wrote approved. So my attitude was that I supported the memo.
Well, I want you to distinguish between two things, because I want to make sure I understand your attitude in regard to each one of them correctly. There is the request which was then before you in October 2015, after Mr. Mlambo had said he needed certain requirements he needed to be satisfied about certain requirements before he could approve, and you approved. Now, that is one thing. That's your attitude to that request.
Yes.
And one of the things you have said is because of urgency, you thought approval should be given. Okay, that's one thing.
Correct.
But the other one is you become aware that there has been a breach of policy some time back when the MOA was signed without his approval. His approval is being sought after, but it should have been sought before. So what was your attitude to the fact that there had been a breach of policy by those who signed that MOA without first obtaining approval?
In my understanding, Chair, the Group CEO applied his mind when he signed the MOA. In his mind, I trust and believe that he would not have breached any policy at that point in time. I trust and believe, otherwise why would he want to breach a policy purposely?
So is your answer that when this came to your attention, your view was that either Mr. Mlambo's, well, I guess you couldn't say Mr. Mlambo's approval had been obtained.
Correct.
So I guess you would have said there must have been good reasons for the MOA to be signed without his approval. Is that what you thought? Is that what you thought?
Correct. Correct, sir.
But you didn't check whether there were actually good reasons. You took the view that the person who was Group CEO at the time approved, and you left it at that.
The representative of Group Supply Chain, as it reported to the former or the erstwhile Chief Financial Officer, in my mind, that represented the whole function of that organization, and he signed it. So I had no doubt, I had no reason to believe that there was breach of policy.
Mr. Kennedy.
Thank you, Chair. Mr. Ntshepe, but you did have good reason. You may not have had reason at the time that Mr. Saluji signed it originally to believe there was a breach of the policy. But here, there was an attempt being made by DLS to cure what had already been identified as having been a breach in the policy. So the mere fact that you thought Mr. Saluji wouldn't have signed unless, at least where he knowingly was aware that the policy had breached, that must have fallen away. You are being alerted now as his successor to the fact that something had been signed by your predecessor in circumstances where the necessary approval had not been obtained. So I'm suggesting to you it may not be appropriate for you to say, well, because Mr. Saluji signed, therefore I assumed everything was in order. You now knew surely that everything was not in order. Specifically, this provision of the process had not been complied with. Wasn't it your duty as Group Chief Executive to take corrective action?
Honorable SC, cannot be 100% certain that Mr. CEO, Mr. Saluji, would not have signed this motivation, number one. So I cannot attest to that.
No, but sorry, Mr. Ntshepe, I think we're at cross purposes. I'm not talking about Mr. Saluji signing this motivation, because this motivation was submitted when you were Group CEO, not when Mr. Saluji was. I'm simply saying this. You are now faced, when you signed to approve this motivation, you were aware that the MOA had previously been signed in circumstances where the necessary approval under the procurement policy had not been obtained. You were aware of that. Mr. Saluji may or may not have been aware of that, but you were aware of that. There is a problem that the memorandum is asking, can we fix it by way of approval, where there has been a breach of the procurement policy? Mr. Mambo said, well, maybe, but I need to be satisfied there's a good business reason before I give my approval, and you overruled him. Not so.
Maybe, can I put it this way? I think what Mr. Kennedy is saying to you is, you have said to me in answer to a question I put to you, that you would have thought that there would have been no breach of policy because
Correct.
Mr. Saluji, as far as you are concerned, you didn't think he would approve if there had been a breach of policy.
Correct.
Which might mean, as far as you are concerned, either there was no breach of policy, or if there was breach, it was a breach, there were good reasons for him to approve. So what Mr. Kennedy is putting to you now effectively is to say, but Mr. Ntshepe, you couldn't have thought along those lines when you had to make a decision on this memo, because the facts which emerged from the memo were that no approval, Mr. Mlambo's approval had not been obtained. That's number one. Number two, those concerned were now bringing to you the fact that there had been no approval, and they are not saying Mr. Saluji signed because here were the grounds that justified him to approve. They were simply saying, in effect, no approval was obtained from Mr. Mambo, but we think it should be obtained now. That's what I think Mr. Kennedy is saying. You couldn't have thought along the lines that you say you thought. You thought.
Correct.
You accept that?
Yes, I accept.
Yes. Okay. So, Mr. Kennedy, you want to take it from there?
Yes, thank you, Chair. I'd like to explore the issue of urgency a bit more. The memorandum refers to urgency, but it doesn't say what the reasons for urgency were, correct?
Correct.
Yes.
I see.
Do you know how long it might have taken for an answer to be provided to Mr. Mambo? Because if you look at page 825, he's not saying, I will never approve this. He's saying that DVS and LMT must submit proof that they cannot meet the requirements. He also says prior to the contract being awarded, of course it had already been awarded. But do you know how long it would have taken?
In my view, I see it could not have taken a day or two.
Even more than a day or two. And yet that wasn't done. Nobody came back to Mr. Mambo to say, well, actually, Mr. Mambo, DVS are saying XYZ, they aren't able to do it. And LMT are saying XYZ, they also aren't able to do it. That wasn't done, even though it could have taken no more than a day or two. You're aware of that?
I'm not aware of that, but you are informing me right now, SC. I'm aware of it now.
You can't dispute it, correct?
Sorry, I just missed it.
Can you dispute it or not?
I'm not disputing it.
You're not disputing it, thank you. And is it correct that nobody came to you to say, well, actually, Mr. Mambo, the answer to Mr. Mambo's questions is the following. Nobody came back to you. Is that right?
I think the individual, I don't remember, the individual who brought this to me, because it was not directed to me, would have pointed out that Mr. Mambo did not sign this thing. And when I read it, this is what I read, and I asked him, why didn't he sign this thing? The answer I got was that he's delaying the process. And,
well, yeah, probably that's what you were told, and maybe you also bought into that. But you have said that checking these requirements that Mr. Mambo wanted to be checked could not have taken more than a day or two.
Correct.
So the challenge, therefore, is why couldn't you say, look at whether the requirements that Mr. Mambo is asking to be checked and go back to him? Because, as Mr. Kennedy says, he has not said he will never grant the approval. He just wants to be satisfied that the requirements of the policy are met before he can approve. So if it was something that could not take a day or two, what is it that was so urgent that you had to approve it yourself rather than say, but Mr. Mambo is following policy. You people must respond, check these requirements and respond to him. Let him make a decision after that, because it's not something that's going to take a month. It's just a day or two, and then he can make up his mind. Maybe he will approve, maybe he won't, but he has raised certain issues. Attend to them. Why didn't you say that?
Chair, the individual who brought this memorandum to me, I believe he brought it in good faith. In good faith.
I'm sorry, you say you believe?
He brought the memorandum to me in good faith because he wanted the expedition of the work. And I believed what he told me.
Yes.
I did not doubt because I believed what he said, and I trusted his views, and I then acted appropriately as I deemed fit.
But is what he's told you that Mr. Mambo was delaying the process?
Correct.
Yes, but then your answer, why was your answer not this? Mr. Mambo seeks to ensure that the policy of the company is complied with. It's not going to take long to check whether these requirements are met. It's a day or two. You go and attend to that, go back to him on those requirements. Come back to me only after he has looked at your response, and if he still says no. Why didn't you do that?
I did not do that, as I will repeat again, Chair, that I believed that DVS and LMT, the individual who brought this to me is aware that DVS and LMT might not necessarily or does not have the capability and capacity to these specialized requirements for the T5. And therefore, he brought it straight to me because he realized that if we do not do it now, we might never do it, or it might take a long time, or it might never happen.
But Mr. Ntshepe, the heavens were not going to fall if in 2 days' time they went back to Mr. Mambo.
Correct, sir.
Yes.
Correct.
So you are the acting group CEO. You are supposed to, among other things, make sure that the policies of the company are followed.
Correct, sir.
Here is a functionary or somebody who holds a particular position in the company, and his duty includes enforcing this policy, and he is not saying, I'm refusing. He says, I want to make sure that the policy is complied with before I make up my mind. And in your own version, it's not going to take a long to satisfy him one way or another. Don't you agree that your approach, your response should have been, no. Mr. Mambo is raising legitimate issues here. This thing of saying he's delaying, I'm not buying it. He's raising legitimate issues here. The policy of the company requires that he must satisfy himself about this. Deal with this, go back to him. Only after he has made a decision, after you have gone back to him with this, can you come back to me. Don't you accept that that is how you should have handled it?
On hindsight, Chair, as you are pointing it out to me now, yes, I should have done that.
Yes. Okay, all right. Mr. Kennedy?
Sorry, Chair, may I just check something with my colleague?
Okay.
You see, the memo starts on page 824. The first paragraph refers to a previous situation, which, as you pointed out, relates to the TS demo model, which was prior to this particular single source contract, correct?
It's a T5.
I'm sorry?
T5.
T5, I beg your pardon. Yeah. Yes, but that is correct, is it not?
Correct.
That was a previous contract. And Ms. Malashlela is pointing out to the group supply chain executive to whom it's addressed that he had previously in relation to that contract had given instruction that DLS must first explore whether and to what extent DVS and LMT could be used to do that. And it was precisely because of the same provision. So she effectively was saying in this memo, we're aware at her level, we're aware that you, group supply chain executive, previously required DLS to make sure whether we could do it in-house. That hasn't been done for the contract for the single source supply. She has taken it to her executive at DLS to say, we've got on the one hand a violation of this policy. On the other hand, we have the fact that the MOA has been signed in violation of the policy. We have this problem. And she was recommending to DLS management, you're going to have to scrap this contract and start the process to do it in compliance with the policy. But her DLS management overruled her, and so she was now saying to Mr. Mlambo, my board, my executive at DLS are now asking you if you will retrospectively approve it. So, did this not ring alarm bells in your mind to know that there was in fact a violation of the policy that you were now being asked to approve? Sorry, not you. Mr. Mlambo was being asked to approve.
In terms of what is written here, there is a violation of the policy.
Sorry, the what?
There is a violation.
Is a violation.
Yes.
So
however,
yes.
Can I continue?
Sorry, yes.
Mr. Malahlela was part of EXCO. She was not outside EXCO. She was part of EXCO herself.
But she's given evidence that she was overruled by the rest of EXCO. Are you saying that she should be blamed?
No, I'm saying she was part of EXCO. She was part of the decision. I cannot say if we make a South Africa a decision, then I'm saying I individually refuse.
Well, sorry, won't you answer my question? We know that she was part of EXCO. We know that EXCO decided by a majority view that Mr. Mlambo should be asked to give approval. It's addressed to Mr. Mlambo, not to you. We'll get in a moment to how it came to you. But EXCO at DLS accepted, the evidence goes and the minutes reflected, accepted that there was a violation of the policy, but said, well, if there's a violation of the policy, it can be ignored effectively because the MOA has already been signed. So if it was done unlawfully, we are now stuck with it, and we may face litigation from a VR laser if we cancel it. So it's then sent to Mr. Mlambo against Ms. Malashlela's views. Is it fair to suggest that she should be blamed because she sat in the same EXCO meeting that took that decision when she was a minority view that strenuously resisted it?
Honourable SC, I am not saying she should be blamed. I'm stating the facts according to me as I see them in front of me. She said, I hereby request permission to implement. I'm not blaming her, but she is the one who's written this thing. I hereby request. She doesn't say I hereby to implement the EXCO decision. As being part of EXCO, I would believe that she was implementing the EXCO decision.
Yes,
well,
because
maybe let's put it this way, Mr. Ntshepe. Ms. Malahlela made it clear in her evidence that in the particular EXCO meeting where this issue was discussed, she was the minority. She had a different view from the majority. But she was instructed to write a letter to Mr. Mlambo and request permission. So when she wrote this letter, she says, I was complying with an instruction from EXCO. And as Mr. Kennedy said, I think she particularly said that last sentence of the memo where it says, I hereby request permission to implement. She deliberately put it like that, but because she was really against it, but she had been instructed. You yes, now understand her position.
Correct.
Yeah. So that was her position. That's the context in which she said she wrote the letter. Yeah. You accept that she shouldn't take any blame for that if she was carrying out the instruction of the majority in the executive committee.
Chair, my honest opinion, I have to be honest here.
Yes, yes.
It might not be a popular opinion. My honest opinion, she's part of EXCO.
Yes.
And whether she was instructed by EXCO or not, I am outside EXCO of the division, and I'm seeing a letter, and she's part of EXCO, and she's asking for permission to, as an EXCO decision. She doesn't say there was a minority view to say that she is not agreeing with it.
No, she might not be saying this here.
Yes.
But one, she said it in evidence here. Two, There is documentation to which Mr. Kennedy might refer you if necessary, which shows her different view in regard to this issue. So I'm not sure what the point is that you are making, because she is saying, I was against this in the ex-committee, and I expressed my views. The matter was discussed. I believe that what was being done was wrong. I believe that even the route to ask Mr. Mambo to approve was wrong. But I was the minority, so I'm not sure what you expected her to do if she felt what was being sought to be done by the majority was wrong.
Chair, I would have expected her to write something here to say that there also is a minority view that this should not be done. Then, because this is what I only heard in front of me.
Yes.
Yes, and in my understanding is that EXCO, including her, had agreed.
Yes, but now I guess you can take it from us who have listened to his evidence and who have looked at some documents that she had a minority view. If you accept that, then
I accept it.
Mr. Kennedy can take it from there.
Chair.
Thank you, Chair. Now, you dealt previously in your evidence with your view that you never undermined Mr. Mambo. But now that you know the facts, at least in relation to Ms. Malashlela, it seems that she was undermined. She, in fact, gave evidence. And if you watched it online, you may have seen how moving it was, how she was, in fact, how she came to the point of tears before the chairperson in these proceedings when she was concluding her evidence and talked about how demoralized and undermined she felt, where she was giving advice and just being overruled. Now, it just seems to me, I would just want to suggest to you that perhaps it's unfortunate that your finger of blame has been repeatedly pointed at Ms. Malashlela, despite the points that the chairperson has raised with you. And we've not heard any criticism from you, I believe, as to the colleagues who were in the majority, who in fact undermined Ms. Malashlela. Does it disturb you now, as the former group chief executive, that this went on? Whether you knew about it at the time, you know it now. Do you have any comment on that? In my tenure, Chair, at Denel, it was my priority to make sure that everybody at work has the freedom and the ability to do their work without fear or favor. Now, I was not aware that Ms. Malashlela was being undermined, nor did she ever come to me to say that she was being undermined. She might have said it here, but she never told me. Ms. Malashlela gave evidence not only that she was against giving the contract directly to VR Laser without at least exploring whether LMT and DVS could do it. But from the beginning, she'd in fact strongly advised her colleagues within DLS that it should be put out to tender. She gave that advice as well, and she was ignored. In fact, she gave evidence that she put in the recommendation in the motivation that is what should be done. And Mr. Tierbus then changed it, and he's given evidence to similar effect. He changed it. Again, she was undermined according to her evidence. Does it not disturb you that this took place? Honourable SC, I cannot dispute that because I was not in those meetings. I see. Now I want to go back to the point. Who in fact brought this memorandum to you? Because it was addressed not to you, it was addressed to Mr. Mambo. Mr. Mambo said, well, DVS and LMT will have to provide proof, which he didn't receive. Nobody gave that to him. You didn't give that to him. How did this memo come to you? And how did you come to approve it? Who was this individual that you've referred to earlier without naming him or her? If I remember
Honorable SC, it was Mr. Stephan Berger.
Mr. Stephan Berger?
Yes.
Yes. And did you have a discussion with him?
Yes.
About, sorry, just let me put the
Sorry,
question,
sorry.
please. Did you have a discussion with him about Mr. Mlambo's concerns?
Yes.
And what was his answer?
His answer was that Mr. Mambo is delaying this process.
So he criticized Mr. Mlambo?
Yes.
But wasn't it Mr. Mlambo's right and perhaps his duty to ensure that there was compliance with the procurement policy?
I do not dispute that. Correctly.
Does it mean that he didn't, that is Mr. Stephan Berger, he didn't address Mr. Mlambo's concerns on their merits? He just said Mr. Mlambo is delaying the process or something like that.
Well, he did address the fact that DVS and LMT, in his understanding, will not be able to do this work,
Yes.
which is required here.
Yes.
Yes, because we had a discussion. It was not just,
Yes.
yeah.
Now, it seems that the problem then arose with you, because once he has said that, shouldn't you have said to him, then you must address that those requirements, those concerns of Mr. Mlambo on the merits and send him a response so that he can make a decision. Don't come to me at this stage until you have responded to his concerns.
Chair, as I said, there was urgency to do this work, number one. There was urgency to
Yes.
do and complete this work on time.
Yes.
And number two, there were numerous incidences whereby Mr. Berger and Mr. Mlambo were not agreeing on issues, and especially in terms of who is responsible for what. Yeah. Because we had a federal type organization whereby the CEOs will be totally responsible because they will be evaluated at the end of the year in terms of their performance. One, and number two, however, the supervisory part will come at group. So there was a group responsibility, whereas largely it was a divisional responsibility.
But isn't the position that everyone has got their own role?
Correct.
Okay, everyone has got their own functions, and everyone must be given space to do that which they are employed to do.
Correct.
Okay? And sometimes somebody will look at an issue and think he would have liked that issue to be handled differently. But it's the responsibility of the one who is given the function
Correct.
to do it in the way that he or she is expected to do it.
Correct.
Now, the policy, which was quoted in the memo that Mr. Stephan Berger came to you with, makes it clear that Mr. Mlambo was the one who should approve. So, it seems to me that your approach ought really to have been, it's Mr. Mlambo's function to ensure that we follow policy in this regard, supply chain management policy. He has asked for certain requirements. Go back to him and deal with what he is raising, because they are legitimate issues he is raising. It's his function to give approval. Don't come to me. Go back to him. He has raised legitimate questions. Go back to him, And then once he has made a decision and you are aggrieved, maybe you can come to me. But at this stage, he has not made a decision to refuse, or he simply says, I want to be satisfied about this. Go back to him. You appreciate when you look at it now.
I hear what you're saying.
Yes. And
Chair.
you have said that there was urgency, but I thought you and I agreed that there was no agency that justified that approval be given within 2 days. All that was required for Mr. Mlambo's concerns to be addressed was a day or two. There's nothing that was going to happen that was going to harm Denel if there was a delay of a day or two while Mr. Mlambo's concerns were being addressed. You accept that?
A reasonable man will accept it.
Yes, yes. Because it's different. It would have been different if you said in a day or two we had to comply with X. And if we didn't comply, this is what Denel was going to suffer. That would be different. But once you accept, as I think you do, that addressing Mr. Mlambo's concerns for him to make a decision one way or another didn't require more than a day or two, then it seems to me there were no grounds to rush to approve in circumstances where, as I see it, this whole process was still within Mr. Mlambo. It had not been completed. He was still seized with the matter. He just wanted to apply his mind. And that you should have said, go back to him, let him apply his mind, make a decision. If you are aggrieved after that, then you can come to me and then we can take it from there.
Correct.
You accept that?
Yes, sir.
Okay, Mr. Kennedy?
Thank you, Chair. May I just pick up on something you said earlier, that Mr. Burger was expressing frustration that this would delay things, and that there was also a pattern of frequent problems between Mr. Burger and Mr. Mlambo. Is that right?
Correct.
Yes. And that it was desirable to let these things be dealt with at the divisional level. Is that correct?
Correct.
But the trouble is, even if there was a good business reason for it to be dealt with at divisional level rather than head office, your own policy required, and we've seen the provision, that it be dealt with, this issue be decided by the group head of supply chain, not the divisional supply chain, not the divisional CEO. And effectively, where Mr. Mlambo was saying, I can't approve this yet, I need certain things that would have only taken a day or two. Instead, you have Mr. Burger coming along and saying, Mr. Mlambo is obstructing me, it's delaying us, even though the delay doesn't seem to have been really significant, as the chairperson has pointed out. And he's saying he's always frustrating me. Shouldn't you, as a responsible GCEO, have said, look, if somebody has to approve this, it's not you, Mr. Burger. If you think there's a good business case, even if you persuade me, that's not good enough. It shouldn't be left to you, Mr. Burger. It should be left to Mr. Mlambo. Because surely, Mr. Ntshepe, do you agree that you were bound, as the group chief executive of Denel, by its own procurement policy, legally?
I was bound by all policies of Denel.
Including this, correct?
Correct.
But effectively, you seem to be saying, well, because Mr. Burger was complaining that Mr. Mlambo was taking too long and the project was urgent and so forth, that you should just approve it. But that would breach the policy. Not so?
Not as you put it, SC.
So how do you put it then?
There is a motivation of why this should be done via laser. And I believed in this motivation, that this motivation represented the true facts of what was decided by EXCO of the division. And that Mr. Burger said Mr. Mlambo is always delaying him or whatever. Of course, as I say, there were issues now and again between the two. But I was looking at this as an individual memorandum to be settled so that we can be able to move with products and be able to deliver this product.
But can I take you back to the heart of my question? And that is that however you felt that there was a good business reason to get things moving and not to get into a dispute with VR Laser, you have been alerted to the fact that there is a violation of a procurement policy which is legally binding on Denel and legally binding on you as Group Chief Executive Officer. Now, you seem to have been persuaded by the urgency, and the Chair has already debated that with you. You seem to have been persuaded by Mr. Burger's complaint that Mr. Mambo was taking too long or obstructing. You seem to have been persuaded by Mr. Burger that LMT and DVS couldn't do this, even though Mr. Mambo asked for a proof which was never provided. And you also seem to have been persuaded by concern that if you cancel the agreement or you don't place an order under the agreement already signed with VR Laser, they could raise claims and bring litigation. Have I summed up your attitude correctly?
Correct, sir.
Yes. But against all of that, even if one assumes in your favor that all of those were good reasons, surely there was a very bad reason for approving this. And that was a simple point of the law. The law says in order to award a contract, you have to get the approval, not of the CEO, but the head of group supply chain to find a business reason. And you were aware here that that was not complied with. You seem to have gone in with your eyes open into approving something that could not be approved under the policy.
I was aware of the policy. I was aware that there is a deviation from the policy. I was aware that there's a motivation to deviate from the policy. I was not aware that there is a minority view to say that Ms. Malahlela is not agreeing with this. And
Mr. Ntshepe, I'm sorry to interrupt you. You're referring to various issues that you've already dealt with. I understand your evidence. You weren't aware of Ms. Malahlela. I understand that you believed there was a good motivation. I understand all of that. But my point is, let's accept all of those as being sensible reasons that were of concern, that gave you concern. Let's assume in your favor all of that. Didn't you have one serious problem? However strong the other reasons might be, there was a legal obstacle. You couldn't approve this because the procurement policy, that's a legally binding measure, bound you. That's the simple question.
With due respect, Chair, I would beg to differ. I believe that I had the authority to approve this.
Where did you get that authority from?
As being the Group CEO, acting Group CEO.
Group CEO?
Acting Group CEO.
Acting Group CEO?
Yes.
Yes.
Maybe let's put it this way, because I was about to ask you this question. Do you know whether the policy had a provision as to what should happen if somebody is aggrieved by Mr. Mlambo's decision not to approve?
I would not know all the policies, but it's been a long time now.
Yeah,
yeah. And you could talk to HR, I would believe. You could also talk to Mr. Mambo to say, I'm not happy with the way you have handled this matter. I mean, that for me, that would be the logical things to do.
You see, it's very important, or it would have been very important for you as Group CEO, generally, or at least before you approved this, it would have been important for you to establish whether there is a provision in the policy which says what should happen if somebody is aggrieved by a decision taken by Mr. Mambo. Does it say they may appeal to the Group CEO, or does it not say? Because when policies or rules in any organization are prepared, those who prepare them make decisions for reasons that they regard as good, as to why certain decisions must be, or the responsibility for certain decisions must be given to certain specific people and not to so and so, and why there should be an appeal or should not be an appeal, and if there is an appeal, to whom that appeal should lie. They exercise their judgment. You see, they might say, you know, in regard to this matter, these types of matters, the decision of the person occupying Mr. Mlambo's position is the decision. Because
Correct.
he will be having certain expertise that even the group CEO might not have. So he is the one who must make this decision. And somebody else might like it or not like it, but that's how the framers of the policy have decided. And in that case, nobody can pick and choose when they don't like decisions. Just like the group CEO. As the group CEO, you had power to make certain decisions. There would have been many people under you who might not have liked some of your decisions, but the fact that they don't like them didn't mean that they could disregard them or that they could do as they pleased. Everybody is bound by the rules and policies of the organization. That includes the group CEO. If the policy says the responsibility for this decision lies with so and so, the group CEO must respect that those who drafted the policy wanted it that way. And if they wanted it differently, they would have put it differently. You understand that? And if the group CEO and other functionaries might start to say, well, I'm going to disregard policy when I feel like that's a recipe for disaster. You see, it instills a wrong culture. People start not respecting policies of the organization. They start not respecting the rules and so on. And the group CEO must be exemplary in this regard. You understand that?
Correct.
Yes. But you say that you are not aware that there was any provision which dealt with, in the policy which dealt with what should happen if you are not happy with, if somebody was not happy with Mr. Mlambo's decision on these matters.
No, I was not aware.
You are not aware. Okay. Mr. Kennedy.
Thank you, Chair. In fact, we have had regards to the supply chain management policy of Denel, as well as at both group and divisional level, as well as the National Treasury regulations and the PFMA. We are not aware of any provision that actually says that if somebody like Mr. Burger is unhappy with the decision of somebody like Mr. Mlambo, they can go to the group CEO or acting group CEO and ask him to overrule the supply chain executive in relation to this. You're not aware of such a provision either?
No, I'm not aware.
What we are also aware of, Mr. Ntshepe, I know you may have had a fair bit to do with legal issues, but you're not a trained lawyer, correct?
No, I'm not.
So it may be unfair for you to have this put to you, but I just want to put it on the record that, in fact, there is a provision in the PFMA that allows a deviation from a supply chain management policy to be authorized. It doesn't say it can be authorized by the chairperson or the group CEO of the entity. It can be, a deviation can be authorized in appropriate circumstances by National Treasury. Now, were you aware of that?
No,
provision?
I'm not aware of it.
And are you aware, was any attempt made by Denel, by you or anybody else, to approach National Treasury to approve this deviation from your procurement policy?
In particular, this deviation, I'm not aware of it.
Right, thank you.
I'm sorry, Mr. Kennedy. With this discussion that has taken place, do you accept now that your decision to approve this in circumstances where the policy said it was Mr. Mambo who had the power to approve. Number one. Number two, in circumstances where he was still seized with the matter. He had not made a decision yet. You accept that your decision then to go ahead and approve was in breach of the company policy, because the company policy gave that responsibility to him, and he was still applying his mind.
Chair, I cannot totally agree with what you are saying. I'm saying that with the facts before me, the decision for me to approve was based on what I saw and what the discussion I had with Mr. Berger.
Yes, but remember that what I'm putting to you is not whether your decision was justified or not, or was correct or not. But it is whether it was in breach of the policy. And I'm suggesting to you that this discussion that we have had reveals that there is nothing in the policy, and you were not aware of anything in the policy that allowed you to override. Actually, I don't even know if it's correct to say to override Mr. Mambo, because he had not made a decision yet. But there seems to have been nothing in the policy to allow you not to wait for Mr. Mambo to make a decision whether he was approving or not.
Correct, I hear what you say.
You accept that?
Yes.
That was in breach of the policy. Approving it where the policy says Mr. Mambo is the one who has the responsibility to approve, and in circumstances where he was still seized with the matter.
It is a bit confusing for me, Chair, I have to be honest.
Yes, yes. But it's important that you should understand.
Yes,
I don't want you to say you agree when you don't agree.
Yes.
I want you to only say you agree if honestly that's what you... But because you see, if the law says this decision must be taken by Mr. Ntshepe, and while Mr. Ntshepe is busy with the matter, applying his mind, where do I get the license to usurp this responsibility for him and exercise this responsibility myself? Unless the policy does say, under the following circumstances, I can intervene while he has not finished. You see?
I hear what you're saying.
Yeah, in this case, it seems to me that Mr. Mambo was still seized with this request for him to approve. He had raised certain issues because he wanted to satisfy himself that everything should go according to the policy. Mr. Stephen Berger comes to you and effectively asks you to carry out a responsibility that is Mr. Mambo's responsibilities. In circumstances where Mr. Mambo has not said, I'm not approving, he has said, I just want to be satisfied about 1 and 2. So I'm seeking to get your concession that you accept that in that situation, your decision to approve in those circumstances cannot be said to have been in compliance with the policy and was in breach of the policy.
If you put it that way, Chair?
Yes. On reflection after this discussion.
I will concede.
Yes, yes. Okay, all right. Mr. Kennedy.
Thank you, Chair. May I just ask one question that relates to the operational issues you referred to of the difficulty between Mr. Berger and Mr. Mambo, and Mr. Berger's frustration and the feeling that maybe this should be dealt with at divisional level. Do you agree that if there was a good reason to take the group head of supply chain out of the requirements for approval, that could have been done by way of approaching the board to change the delegations of authority and the procurement policy, not so?
Correct. In fact, I think this new policy, this was a new policy because the structure of the organization changed from a totally federal to a semi-federal organization. And this was a fairly new policy.
So
it was a fairly new policy.
So this was a fairly new policy which
Yes.
had given the right and the power to Mr. Mambo to decide this issue, correct?
Yes,
Yes.
correct.
If you felt that that policy wasn't a good one, the newish policy wasn't a good one because it should rather be left to the division, surely the way to do it would not be to violate the policy, but to go back to whoever prepared it and approved it. We know that the board approved these policies, to go and persuade the board, not so.
Correct.
Okay.
And
Now-
you could even actually say the policy should be amended to give you the power to override Mr. Mlambo's decision or to intervene if he is delaying in making a decision. But that would have to be that would have to be part of the policy, because then if it is part of the policy and you do that, you'd be acting in accordance with the policy. But when you do that, when the policy doesn't say that, you act in breach of the policy. You understand that?
Correct.
Yes, okay. I think we must take the tea break, Mr. Kennedy.
As you please, Chair.
We have gone past, way past of quarter past. We'll take the tea break now, or were you keen to ask one or two questions before we take the break?
I'm happy to take it now, Chair.
Yeah. Okay, let's take a tea break now and we'll resume at 11:45.
Thank you, Chair.
Oh, no, I'm sorry. No, I'm getting confused because we started early. I thought it was 11:15.
No.
But because we started at 9,
Yes, it's almost 10:30.
it's only 10:30. No, we can continue, I'm sorry.
Thank you, Chair.
Yeah, maybe we should decide when we will take the tea break, whether we'll take it normal time or...
I expect, but it depends on how many questions are put to the witness and
Yeah.
how long he takes. But I would expect that we would probably finish his evidence in the next half an hour.
Oh, okay, then, which will be 11 o'clock, then maybe we can take it then.
Yes, but perhaps we can review it at that stage.
Yeah, okay, all right,
Thank
let's
you, Chair.
continue, yeah.
I'd like to deal with one final aspect, I believe, in relation to this issue of the single source, single supplier contract that was awarded to VR Laser. You've confirmed that one of the reasons that persuaded you to give this approval, despite the requirements of the procurement policy, was that the agreement with the MOA had already been signed with VR Laser, and there was concern that if you then said, well, we're not going to place an order with you now because there's not been compliance, that could result in VR Laser bringing claims against you and possible legal cases. Is that right?
Correct.
Now, there are 2 points I want to explore with you on that. That could have been avoided if within the next day or two, a proper business case had been put to Mr. Mambo to get his approval. Not so?
Correct. It's not a
Yes.
long time.
If he had given that approval. If he'd not, then you would have still faced a problem. Not so?
Correct.
Yes. The other point is this, that I can understand you would be concerned that VR Laser might take you to court if you didn't honor the MOA. But were you not aware of the possibility, the danger, that if you did approve this and you implemented the MOA, where officials such as Mr. Mambo had said, this provision of the procurement policy has been violated, were you not aware that the Auditor General, for example, might query how this contract had been signed in breach of the procurement policy, or some other entity, maybe a competitor, might have taken you to court? And were you not aware that there was a risk that because there was this violation of the procurement policy, and Ms. Malashlela has identified a whole lot of others, as did Mr. Mambo, that you would then be vulnerable to having the contract set aside.
Chair, in my trust and belief was that every year we have internal auditors who go through all these matters. This matter was never ever brought to me in that year of the financial end of the financial year as a matter that need to be investigated. So I believed that there was no need for condonation, or the Auditor General would have questioned our financials that year. And I trust the judgment of the Auditor General.
Do you know whether the Auditor General was aware of this conflict, this violation of the procurement policy?
I'm not aware of it.
Yes.
Because yes.
Yes. You seem to be suggesting, Mr. Ntshepe, but correct me if I'm wrong, you seem to be suggesting, well, we'd got away with it. They hadn't picked it up, so let's carry on with the problem.
No, it's not correct, SC. What I'm saying is there is a fair assessment of our performance every year by external auditors. I'm not, if there was any problem, there were problems that were picked up, especially like in irregular expenditure, that were picked up, and this matter was never brought up to say that it is a problem. So yes, I'm not suggesting anything that we got away with it.
But you see, that's what concerns Mr. Kennedy. He is saying, is not talking about what happened months later. He's saying, at the time of giving approval, bearing in mind that Mr. Mambo was saying certain requirements should be dealt with first, were you not concerned that if you approved, this is something that could be picked up later by the Auditor General to say there was a violation of policy, because then it would come back to you to say you approved. How did you approve something that was in violation of policy? That's what he is asking. Were you not concerned about that?
In my honest opinion, Chair, I was not concerned because I believed it was correct.
But now, when you look back, do you accept that you should have been concerned?
Yes.
Yes, okay, all right. Mr. Kennedy.
All right, thank you, Chair. Does this not illustrate the importance for a GCEO like yourself to actually be taking seriously the concerns of your colleagues such as Mr. Mambo when they are raising issues like this, to investigate them properly and not simply go along with what Mr. Burger told you?
Chair, I have always taken the concerns of the people I worked with at Denel very seriously. And this matter, in my judgment at that point in time, was an urgent matter. I am, as you said, I cannot be able to expatiate more than that and start speculating that I was not taking him seriously. I took him very, very seriously. That's why he worked there.
Chair, with your leave, may we then move on from this topic to the next issue that is dealt with in Mr. Ntsepe's affidavit, and that is the single source agreement between DVS as opposed to DLS and VR Laser. You deal with that, Mr. Ntshepe, at page 517 of your affidavit. Sorry, you can put away file 1. I should have told you. Put away file 1 if you would. And then, Chair, we're going back to file 8.
517.
517, yes.
Still trying. Yes.
Now, you were asked questions by the investigators that gave rise to these answers, correct? Mr. Ntshepe, did you hear?
I missed that. Pardon me, Asi?
The investigators asked you certain questions about how it came about that you approved the transaction
correct,
for
yes.
single supplier contract from DVS. We've moved away from DLS.
Correct.
And there has been evidence from other witnesses to the effect that you gave an instruction, particularly to Mr. Steyn and Mr. Wessels, that they negotiate with Mr. Van der Merwe to secure this contract, correct?
Correct.
Yes. In fact, you, at page 517, 4.1, you say there's nothing unlawful about my instruction that Mr. Johan Steyn and Mr. Jan Wessels negotiate with Mr. Pieter Van der Merwe because we had already signed a single source agreement with VR Laser. Now, the single source agreement that had already been signed was the one that you had approved for VR Laser to be a single supply for DLS, correct?
I was a witness. Correct.
Yes, you were a witness to that. And you then approved the overriding of Mr. Mlambo's concern about the policy that we've just dealt with, correct?
Correct. There were other contracts which were signed also.
Yes. So, as I understand it, you don't dispute that you gave an instruction to Mr. Steyn and Mr. Jan Wessels that they should negotiate this contract with VR Laser
Correct.
for
Correct.
DVS's single supplier.
Correct. Correct.
Yes. And why did it come from you, though? Why did this instruction come from you? This doesn't appear to have been something that came from divisional level.
Okay. There was a resolution from the board whereby the three divisions that were land-based divisions should merge as one division because basically they are juxtaposed and they complement each other. One was DLS, the other one was DVS, and the other one was LMT. And the board was expecting that in the end, there should have been cost savings, and I should be able to show those cost savings. So when I gave the instructions to the two gentlemen was because of the resolution from the board saying they should come together, and secondly, that the matter of savings should bear fruit. There would be no point in having three divisions come together and then you find the cost increases. So the issue of saying that I instructed them, yes, I concede and I agree that I didn't instruct them. And the motivation was that the board had taken a resolution that they should come together. Which I believe, Chair, when I hear is that currently they have done that now.
Sorry, this currently?
They have done that now, as Denel.
Yes. But let's turn specifically to the instruction to appoint VR Laser as single supplier for DVS. I understand that there was an intention to rationalize your divisions, the three divisions that you've identified, including DVS. But we know that the single supplier contract awarded to VR Laser by DLS was done without following a tender process or a procurement process, correct?
Correct.
Yes. So the fact that you had already awarded that, the Denel had awarded that contract without following a procurement process in favor of VR Laser, that surely didn't entitle you to do the same thing for the DVS single supplier without complying with procurement processes?
As I have explained in my affidavit, I think is it 2.55, if I'm not mistaken? Let me just...
Yes, well, perhaps just tell the Chair
Yes.
what you want to say about that.
2.5.
You want to refer us to page 215, did you say?
Yeah, no, page 514 and page 515.
Yes.
2.5.
Yes.
As I have explained, that the MOA had already been signed with DLS. It is one organization. For me, it did not make any business sense to go out and find other suppliers whom the products still have to be qualified, because every product that the suppliers that supply to Denel must be qualified to meet the Denel standards and AMSCO standards. And if you go out again and do a qualification, and the cost of qualification is very high. In other cases, it surpasses more than 10 million rands. So now that we have an agreement with an organization which had already qualified its products with Denel and also with AMSCO many years ago, not even before the acquisition by ESA, and we have signed a single source agreement, it made sense to me, and it was logical for me to rationalize the organization and show cost savings. And in my understanding, that the cost savings came to about 80 million rand.
How would those cost savings be achieved? By appointing VR Laser without a competitive process?
Well, cost savings in the sense that there will be one organization. In the end, it was going to be one organization.
One Denel organization?
One land systems organization in Denel.
Your divisions, your three divisions would be incorporated into one, yes?
Yes. Therefore, there's a duplication of staff. One will be, there'll be a reduction in staff. And number two, we will have more power to negotiate prices and be able to squeeze prices to our suppliers, to say that we are now a bigger organization, we have therefore have a bigger need, and you will be getting more revenue as a supplier. In any organization whereby you get a bigger order, the price goes down.
Yes, I understand that, but surely those two reasons that you've just given are reasons why it may have made sense from a business and financial point of view to merge the three entities of Denel.
Yes.
It doesn't seem to me, unless I've missed something, that is a good reason why you should not allow a competitive process. Assume for a moment that we accept that if you merged your three divisions, you would have greater purchasing power.
Yes.
You would have more bargaining power.
Yes.
Suppliers would give you better prices, correct?
Correct.
But that would happen also if you went out on a tender or a competitive procurement process, perhaps even more so. So I'm struggling to understand, unless I'm missing something. I'm struggling to understand why merging the three divisions is being raised as a reason why you were deviating from procurement processes which would have allowed a competitive process. If you would please focus on that.
It is not the only key focus, as I've indicated.
Okay. What else?
The other focus was that we already had an agreement, a single source agreement at this point in time with an organization that has been its product. And as I've said yesterday, that those products, it's not just a product, it's something that protects our soldiers. Especially, and if anything happens, there will be bigger problems than Denel is experiencing. Therefore, the goods must be of high quality, high value quality. And it takes time and what you call evaluation to make sure that those products meet the standards of AMSCO and also of Denel. So
yes,
I would therefore believe then that with the VR laser being a qualified supplier, and we have a single source, there should be one agreement, and we will be able to in fact, I think they also consulted Mr. Stephan Berger on how he did his agreement. I think it's in one of the reports, I don't remember, or in one of the emails. It does say that. To see how they did it.
Well, let's leave out of account what Mr. Berger says. He's going to still give evidence
Yes.
this week. He can speak to that himself from his own perspective. Yeah. I'm asking you for your perspective. Now, I have no difficulty with your point that VR Laser was already accredited with ARMSCORE.
Yes.
But they weren't the only party that was accredited with ARMSCORE or was capable of being credited by ARMSCORE. This wasn't a situation, for example, that there was only one single supplier of this type of component or equipment in the world.
In the world?
Namely VR Laser. Not so.
No, we are talking about, because we have to grow the economy of South Africa. We are talking about a South African company.
Okay.
Yes.
So if you confine it to the South African market, this wasn't the only potential supplier, not so.
Well, the other suppliers, as far as I know, I am not an engineer, they did not meet the requirements and the standards of in particular of Denel, and Denel has to meet the standards of ARMSCORE.
DVS itself was manufacturing this type of component and equipment.
DVS had closed its fabrication division. And I see that they are claiming that they did not. They did. After the Iraq contract, which was done for the Americans, they went from a 3 billion rand company to less than 800 million company within a year. And one of the reasons they had to lay off. But up till today, after I've taken this decision, they have not made any retrenchments.
Yes. Are you aware that Ms. Gildenhuys has testified in these proceedings?
Yes.
And are you aware that that she gave a very, very different picture to you? She was part of the EXCO senior management team at DVS.
Ms. Gildenhuys, I rarely interacted with her.
Yes, I'm asking you, are you aware that she gave evidence?
Yes, I am aware.
And are you aware that she gave evidence that it made absolutely no sense from a business point of view for this contract to be given to VR Laser, where DVS could make the items themselves?
I do not agree with her.
And she gave evidence that Mr. Steyn, her boss, who was the divisional CEO of DVS, correct?
Correct.
And he also was unhappy about exactly this, and in fact recommended against giving this single supplier contract to VR Laser for the same reason. I'm aware,
I see. But so I do not agree with what
you disagree with Mr. Steyn as well?
Yes, I do not agree because he's saying that I forced him. He's far experienced in the business than me. He's a mechanic. He's far experienced and is senior than me in the business. Actually, grew up in the business. Who am I to force him to do something that he doesn't? He knows the process. If he had a begrudgingly or a grievance, he knew what he had to do. Why did he then agree to exercise this process? There's no way, I have never ever in Denel forced anybody to do anything. But I would put my authority and say that this is what is required because my operating style was that this is a business, this is not a department of government.
But isn't that exactly what you did? You gave Mr. Steyn the instruction that he must contract with VR Laser, an outside company, as a single supplier and he was against that. Are you saying that he actually was in favor of it?
He had reservations, but I said this needs to be done. I did not force him. I mean, if he had reservation to a certain extent that he felt very strongly against this instruction from me, he knew exactly where to take it.
When you say he had reservations, were they not very serious reservations? Were they not serious reservations?
To me, it was not serious reservations.
In fact, the emails that Ms. Geldenhuys took us to previously, in fact, showed that he was very unhappy about it. Were you aware of that?
I've never had a discussion with Ms. Geldenhuys on this issue. So it was for me even a shock to see that she is saying all the things and being very dramatic about it, all the things that you said about this contract.
You see, Ms. Geldenhuys has given evidence that she felt that she and her colleagues were being undermined at DVS. Ms. Malashlela has given evidence that she was being overridden at DLS by her exco, and ultimately you overrode Mr. Mambo. Ms. Malashlela and Mr. Mambo have given evidence that they felt that they were being seriously undermined by what was being done, and Ms. Geldenhuys has given similar evidence. There just seems to be a pattern, Mr. Ntshepe, of senior people responsible for procurement issues, and also in Ms. Geldenhuys' case for legal issues, legal compliance issues, and a member of senior management, where they felt undermined. Are you saying that they didn't feel undermined, or are you saying if they did feel undermined, they had no reason to?
I'm saying, SC, that if they did feel undermined, they knew the due process how to voice their grievances. They could even have gone to the department, if need be.
Gone to the?
Department of Public Enterprise.
Department of Public Enterprise.
Yes, if need be, to say that the CEO is undermining our responsibility to do our job.
Doesn't that put somebody in, for example, Ms. Geldenhuys or Ms. Malashlela's positions, both holding senior positions within their divisions, but way below you within the organization? Is it seriously suggested that they could and should have escalated to the Department of Public Enterprises to go right over your head? Wouldn't that have been extremely difficult for them to do?
In my understanding, our government has an open policy whereby individuals, if you have a problem, you can find a way to express your grievance. If they are professionals, they are lawyers, both of them, Ms. Geldenhuys and Ms. Malashlela, I would actually expect them to do exactly what to do. But whether they go to the department or not go to the department or go to HR, they should know exactly what to do.
Instead, all three of them ultimately resigned.
I was not there when they resigned. One went overseas because he was recruited by another country for his own benefit. And the other two, I left Denel, they were still there.
We've already heard your evidence that there was good business reason to leave many decisions in the hands of the divisions, and that was one of the reasons that informed you to support Mr. Burger at DLS in implementing the contract already awarded to VR Laser.
Correct.
But the contrary seems to have happened in the case of DVS, where Mr. Steyn and Ms. Geldenhuys objected, or at least raised serious objections, or as you put it, reservations. And you then said, well, I'm Group Chief Executive Officer, you're going to do what I'm telling you, effectively.
It is not correct, as said. This is not what I said. What I said was to say that there was a board resolution to rationalize the companies, and you have to take action in that. So it was not just an arbitrary decision from me to say that you also go and contract. I was moving towards and actioning towards achieving that board resolution.
The board resolution may have said we approve the rationalization so that 3 divisions will be merged into one operation, the land-based entity that you were referring to. It didn't say, however, that in that process, VR Laser should be given a single supplier contract, not so.
No, it also says and show savings in the process, because it will not help to rationalize organization and have a balloon structure.
Yes, but it didn't say that VR Laser should, as a result of that, be given a single supplier contract, correct?
These are one of, yes, it did not say that.
Right.
Yes.
And it didn't say that it should be given a contract in violation of the board's own procurement policy and delegation of authorities, not so.
I think, I see, I've explained the role of VR Laser, Chair, in Denel. There are differences, and I've considered in areas whereby I needed to concede, or you made me understand. And I've also explained the reasons why I took those decisions. And this is one of those decisions whereby I took in order to rationalize the organization. Other people could have done it differently.
Now, if I can take you back to 518. Can I just confirm, you gave the instruction to enter into the contract with VR Laser for DVS, correct?
Correct.
And did you actually sign that agreement?
No, I did not.
Why not?
Because Mr. Stein asked me if he could sign it, or should I sign it. I said, no, you can sign it.
Mr. Stein signed it?
Yes.
But that was after you'd given him an instruction to give the contract to VR Laser and to sign
He
the
could have
agreement.
refused to say, I'm not signing it.
He could have refused.
Yes.
But he would have been refusing an instruction from you as his ultimate boss, not so?
What would be the consequences of that? I don't think he would know exactly what he would be doing. And I don't think that I was forcing him to sign it. I mean, it was a free will. It was not forced on him to say, you sign it, or there will be consequences thereafter if you don't sign it.
Now, Mr. Ntshepe, at page 518, your affidavit has paragraph 4.2 at the top. Are you there? Are you with me?
Yes, yes.
Right. This is what you say. With regards to evidence suggesting that the DVS concluded the MOA with VR Laser services without following Denel procurement policies, I do not know to what extent such policies were not followed. And you, presumably the investigators, have not stated the extent of that non-compliance. I would therefore not know whether or not procurement policies were followed, as this was a division of Denel handling its own procurement processes in this regard. And then you say, I must, however, point out that DVS was a newly acquired private company that was still governed by their policies. It was agreed that DVS will migrate to government SCM policies over a period of time. In my understanding, the Ministry of Public Enterprises was aware of this. Now, let's unpack this, if we may, Mr. Ntshepe. You refer at the top of your paragraph to the fact that you were aware that there was evidence suggesting that this particular contract between DVS and VR Laser didn't follow Denel procurement policies. And you say, well, you don't know to what extent that was not followed, so you don't know whether, in fact, they were followed. But you're aware that there is evidence before the Commission. That's why you were responding to this. That's why you were saying this. And the evidence is clear that procurement policies were not followed, for example, in that there was no competitive procurement process followed. And secondly, that the correct level of authority did not sign or approve the transaction. Now, may I suggest that you seem to be saying, well, you don't know about that, and you don't perhaps care about that.
It is not correct.
Okay, just explain, did you care then?
I cared very much. I spent 21 years in Denel, so
Yes.
I cared very much about the success of the organization,
Yeah.
and I contributed very significantly, I believe.
But you've already conceded some of the concerns that the chair has raised with you as you sit now with the
Yes,
benefit
but it does
of
not
the
mean that I
discussion.
did not care about the organization. Chair.
Yes.
I conceded it could have been mistakes, but it doesn't mean that I did not care about the organization.
Okay, well, so you did care. All right, that's good. But if you did care, was it not important that you ensured that before you gave an instruction to Mr. Steyn, that you were satisfied that there was proper compliance with procurement processes?
Mr. Steyn and Mr. Johan Wessels were both involved, and I think to a certain extent Mr. Berger was also involved. I think they were asking for advice of how he concluded his via laser single source. If there was a problem, and if they didn't, they might not have signed it willingly, but they had recourse. They could have been even put me in a disciplinary process if through channels which I would believe they would know. So what I'm saying is that I cared, and the policies of this organization, as I further go down, is that they were in transition. They were not totally a state-owned policies, and the Treasury was aware of that because a letter was written to Treasury on that matter.
Mr. Ntshepe, what I'm asking is really about your own state of mind and your own conduct. Now, I understand your evidence that if Mr. Steyn or Ms. Geldenhuys or anybody else had felt that the instructions that you gave to award a single supplier contract from DVS to VR laser was wrong from a legal or a business point of view. I understand your point that they could have laid a complaint against you within the organization or with the Minister of Public Enterprises or whatever. Before you even get to that point, before you decide to give that instruction to them to carry out, which may result in them being unhappy and potentially raising a complaint against you, before you decide to give that instruction, was it, if you cared about compliance with procurement policies,
Yes,
was there not a little question that went off in your mind? Can we actually give VR Laser this contract without following procurement policies? And can I give an instruction to my juniors in the group to give that contract to VR Laser if there may not be compliance? That's what I'm asking you. So don't trouble us at the moment, please, with whether or not Mr. Steyn or Ms. Geldenhuys should have reported you for taking that decision. Just focus, please, if you would, on whether you could and should have taken that decision.
I believe I should have taken that decision, Chair.
You're entitled to take it?
Yes.
And there was good reason to? Good business reason to?
Yes, to me
Yeah.
it was a good business reason.
Now, did you ask yourself the question, is this permissible to give it to one entity and not allow a competitive process to allow others to tender or to quote?
Chair, I've already indicated the reasons why we chose VR laser. And to me, it made business sense not to have or to piggyback on the existing agreement that we have with VR laser. And I've been instructed by the board to rationalize the organizations, the 3 divisions. And it made business sense for me to say, okay, we already have this agreement, and for the supply of steel in any event, DVS was buying steel from VR laser. In any event, it would not have done any harm. Actually, for me, it would have made savings in terms of the operations of the organization. Therefore, in my mind, I believe I was correct.
How do you know there would have been savings? If there was no tender or quotation process that was competitive, you could not know what prices might be offered by other potential bidders.
Well, there were projections made when they were doing this exercise. There were projections made. The figure of 80 million is not an arbitrary figure. It was a projected figure.
Projected on the basis that the three divisions would be merged?
Yes.
Or projected on the basis that VR Laser would supply it at a certain price?
The three divisions will merge, and the operations of the three divisions will when they merge, will be enough to cover the three divisions without getting extra or cost any other, what I would say, cost in terms of getting new suppliers, requalifying those new suppliers, etc. But the three divisions will merge and there will be cost savings. And the cost savings will be internal and also external.
I understand that cost savings may have been achieved if the three divisions were merged, but I'm interested in a different point, and that is, how could there be projections that you would save if you went to VR Laser if you as an organization didn't go out to the marketplace and find out how much each person would be prepared to offer?
Chair, I've already expressed the issue of volumes, to say that if you have larger volumes, you would have been able to get a lesser price. And that would have been a cost saving in my mind. And secondly, the employees of Denel, especially the engineers, in particular, that were involved in these types of activities, know the workings of VR Laser, than finding a new company whereby it will take a bit of time to understand their systems of working. And also the matter of AMSCO now requalifying that new supplier.
But Mr. Ntshepe, the procurement policy doesn't say, well, when we think as an entity that we might get better prices through bigger volumes, so let's give it to the same party that is already with us in another contract, so let's give them another contract. It doesn't allow that.
It has happened before.
I'm sorry?
It has happened,
it's happened before.
Yes.
Are you saying two wrongs make a right?
No, I'm not saying it's... You are now telling me it's wrong.
I'm asking you.
In my mind...
He was saying the policy doesn't allow that, and your answer was it does happen, but your answer should address the question whether what the policy allows and what it doesn't allow, irrespective of whether people comply with the policy or not.
Okay, maybe...
Do you want to repeat your question, Mr. Kennedy?
Yes, if I may. That the mere fact that a party such as VR Laser already has a contract with one Denel company, namely DLS. The procurement policy doesn't say, well, if you've already given a contract to VR Laser from DLS, that entitles you to avoid compliance with the requirements of a competitive process. You give another contract for a different division, DVS. Do you disagree? Does it allow that or doesn't it allow that?
As the policy stands, it doesn't allow that.
Doesn't allow that?
Yeah.
And yet you were instructing people to do exactly that.
I've indicated to you that after the discussions that we've been having, and after the chair has showed, expressed what should have happened, I consider to say that that is, I concede to the fact that is correct. This is history. The issues that we're talking about here are things that have happened in the past. It's not something that is going to happen in the future. If I was, it's like asking me if now you know would you do it the same thing again? Of course, I would not do the same thing again.
Okay.
It just seems...
I guess your answer is now you see that it was not right or it was against public policy. But you are saying that at that stage you didn't see it that way.
Yes, correct.
Mr. Kennedy?
Thank you. May I just suggest to you, isn't it a great pity that you only come to realize now and concede that there were these irregularities under procurement policies when the matter gets to the level of a judicial commission of inquiry and when counsel such as myself puts these points to you? Were you, as the group chief executive officer, not required to know this sort of thing yourself? And if you didn't know, to go to the experts, such as Mr. Mambo, or get outside legal advice to say, can you do this or can't you do this? Instead, years later, you're now conceding, well, in fact, I accept that I couldn't do this under the procurement policy. It just seems to me that as Group Chief Executive Officer, you should have known this before, and if you didn't know about it, you should have at least gone to, for example, Mr. Mambo and said, Mambo, you are the expert in procurement policies. Can I do this or not? And yet he seems to have been sidelined or overruled. Any comment on that?
With respect, SC, you have made points as if I was deliberately taking decisions to break the policy of the company. And in my view, I was not. And as I say, that's hindsight, that's history. And that I have to come to the commission and say that, yes, it is fine. Where would I have said it? I don't think that it is. I mean, it's a sin for me to say, okay, Chair, what you're saying makes sense. It is. I think I'm not embarrassed to say that. I'm saying it with good faith.
I think the proposition that Mr. Kennedy is putting to you for your comments is that as Group CEO, you ought to have been familiar with what the policy allows and what the policy did not allow, but that where you were not sure, you ought to have approached people such as Mr. Mambo or even outside experts or advisors to advise. Is suggesting to you that you didn't act in the manner in which a Group CEO would have been expected to act. What do you say to that? That's what he's putting to you.
Chair, I do not agree. I acted in the best manner for the company. I believe that. I do not agree to the fact that I was basically being negligent and I ought to have known that if I did not know, I ought to have known that this is not correct to do. We already had an existing contract of a similar nature, and it was accepted and it was operating. And as now it's been pointed to me that if it has happened before, does it mean it must continue like that? I'm being told that the contract was wrong. So I say, I hear what you're saying, and I am in a position to hear what you say, basically, Chair. But in my belief that we were doing, or I was doing things for the interest of the company and nothing more.
Of course, when you look at whether your decisions were or were not in the best interest of the company, one has got to make a distinction between two things. There may be a decision that on its merits might seem to be in the best interest of the company, but the process that is supposed to be followed before a decision is made might be something else. And,
Correct.
and following legal processes and following the processes of the policy and complying with the policy is also in the best interest of the company.
Correct.
You accept that?
Yes, I accept it.
Yeah, okay. Mr. Kennedy, we are at 11:15.
Yes, Chair,
11.
perhaps this would be a convenient time.
Let's
I want to
let's
try
take the chair adjournment.
Yes, thank you, Chair. I
Yeah.
want to just wrap up with his evidence as briefly as I can.
Yes, no, that's fine.
But if we can take the tea adjournment now, it'll enable my learned friend in the team to give the input that she wants me to.
Yeah, no,
Take
that's
note of.
fine. We'll take 20 minutes instead of the normal 15 minutes for me to attend to something.
Thank
So
you,
we
Chair.
will resume at 25 to 12.
Thank you, Chair.
We adjourn.
Thank you.
Okay, let's continue.
Thank you, Chair. May I just deal finally with a few further issues? In relation to Denel Asia, during your time as GCEO of Denel, is it correct that Denel then brought legal action against the Treasury, National Treasury? Just switch on your microphone, please.
Switch on your mic here and face this side when you give answers.
Apologies.
Okay, all right.
Was that decision taken by yourself?
Well, the decision was taken by the board.
By the board, on your recommendation?
It was a decision taken by the board. There was no recommendation from me, but it was taken by the board.
So who came up with the idea?
I would not remember because we had so many board meetings.
Doesn't it make sense, though, that it must have been initiated by you as the Group Chief Executive Officer?
No, to me, because I did not initiate it, it doesn't make sense because I did not initiate it. It's the board.
But you can't remember who it was?
Yes.
Yes. And are you aware that there was non-compliance with Section 54 of the PFMA?
In terms of our understanding, when we put in the application, we complied with Section 54 of the PFMA.
Ultimately, the court application was withdrawn by Denel. Is that right?
I do not remember.
You don't recall?
It's been such a long time.
Now, were you party, though, to the discussion at the board meeting where it was decided to bring a court case against National Treasury?
Yes, I was in the board meeting.
And did you agree with it, the decision?
I did not oppose the decision.
You didn't oppose it?
Correct.
Yes. Did you or your board colleagues consider the implications for Denel of bringing a legal action against National Treasury?
I would believe yes, they did.
Well, if you were at the meeting, you would know who came up with the idea at the meeting that this is the decision that the board should take. You would have been aware who raised the issue or who moved for this decision to be taken.
Chair, if I may address you, I'm being honest when I say that I do not remember exactly, because I do not want to label people and find that I do not have the evidence to support that.
No, it's fine. It's fine if you do not remember.
Yeah.
I'm just saying,
yes.
If you were at the meeting,
yes.
You would have known, at least at that time, who came with the idea at the meeting, who raised it. But I accept that a number of years after, you might not remember. Could it have been a matter that the chairperson of the board raised? Because I think, if I'm not mistaken...
I think because it was discussed at the board and he was the chairperson of the board, in the end, I also believe that he did not oppose it because a resolution was taken that we should put a court case against the Treasury.
I can't remember now, but you may remember who deposed to the founding affidavit.
I did.
You did?
Yes.
Okay.
Thank you, Chair. May I proceed? Thank you. I'd like now to deal with evidence that the Commission's already heard a week and a half ago from Mr. this week from Mr. Mshlontlo, about the circumstances of his being suspended and the Commission a long time ago has heard the evidence of Mr. Saluji. You were at that stage the head of business development in the group. Is that correct?
When he was suspended, I was asked to act.
Yes.
Yes.
I mean immediately before they were suspended and you then came into act.
No, it was after they were suspended. I was called into a meeting and asked to act. It was recorded.
And the evidence that Mr. Mhlonhlo has given is that he was called in. Each of the three were called in one by one. So he was called in, and that you happened to be at the office at the time the board was having its meeting when the suspension was decided upon.
Correct.
Is that correct? The meeting started round about 6 o'clock in the evening, he gave evidence, as did others, particularly Ms. Mandindi. It was supposed to have started at 5, but the Audit and Risk Committee had a meeting first, and about an hour later the full board meeting took place, and that then lasted well into the evening. I think around about 10 o'clock is roughly when the decision was taken.
Correct.
And
correct.
were you at the office throughout this period that the board was meeting?
Yes, not throughout the period, because I did not know about the audit and risk. It's the first time I hear it. I was in the office when I think the main board said I was in my office. Yes.
And were you then called in that evening to see the board?
That was the first time I was called, not again. First time I was called after the suspension.
After the suspension, but
Yes.
that same evening?
Yes.
Yes. You see, the perception of some of the witnesses, such as Mr. Mhlonhlo, is that even before they were heard, now I appreciate you weren't yourself part of the board meeting that decided on their suspensions, correct?
Correct, I was not.
Yes. But the perception that has been created is that this was all just engineered, that their so-called hearing before suspension was a farce, and that you had already been picked to take over in an acting capacity once Mr. Saluji was suspended. Do you have any comment, any knowledge that you can add on this to the chairperson?
Chair, in my understanding, this was not a farce because this meant a serious matter of people's careers. So it was not a farce. And secondly, I worked with this team that was suspended very closely, very close, especially the CEO. I was very closely worked with him. I was asked by the chair not to leave that day, and then he would let me know. That's why I was there in the evening.
So he
it was not.
I'm sorry, carry on.
Yes, I was asked by the
You
chair.
were asked not to leave for home that day.
Yes, because it was
until they had spoken to you.
Until yes.
Yeah.
Yeah, I would assume until they had spoken to me. Yes.
Yeah. Okay. So in other words, they asked you not to go home until they had come back to you in one way or another.
Correct.
But were you told why? Were you not at that stage?
No, Chair, because I was asked by the Chair not to leave. I believed that there must have been a good reason for him to say that, but I was not told.
Okay.
Well, when did he make that request? That's Mr. Mancha you're talking about, is that right?
Yes.
When did he tell you not to go home? Before the board meeting?
Huh?
Did he raise that before the board meeting started?
Yes, before the board meeting.
Otherwise, you would have gone home that evening.
It was around 6.
Around 5 or 6.
Yes.
Right. And he didn't tell you what they were going to talk to you about?
No, he didn't talk to me. I saw him for a very short time.
And after that, many hours later, do you agree it was around about 10 o'clock that you were called in?
Yes, it could have been around 10 o'clock.
Did Mr. Mancha have a discussion with you privately before you were called in, or did you just go in?
No, he did not have a private discussion.
So you had no idea while you were waiting all these hours that it might relate to
I did
your
not.
acting?
I did not.
And when you went into the board meeting as requested, did they indicate the purpose of calling you in was to arrange for you to become acting group CEO in light of Mr. Saluji's suspension?
Yes, they did. In fact,
Yes.
it's on record.
Yes. Was that all that they raised with you? That was the reason why you had to wait those hours?
If I still remember that evening, that was the main thing.
Right, thank you.
Yes.
Must have been frustrating to
If-
be told not to go home around 5 or 6, and then 8, 9, you have not been called, and you are only called around 10 p.m. to just wait when you don't know exactly what the issue is.
It could have been me that I was going to be fired. I don't know.
Yeah.
Yeah.
By this time, that is September 2015,
I'm sorry, Chair.
yes, no, I'm sorry. By this time, namely September 2015, I take it that you and Mr. Salim Essa had come to know each other quite well, because I think it was in 2012 or 2013 when Mr. Saluji introduced him to you and said you would be the contact person for him, or he would deal with you.
Correct, Chair.
So you had come to know each other quite well by September 2015.
In short, correct, Chair. But as I have explained before, relationships to me are very important, especially for the job that I was doing. I was
Yes.
doing business development and new business development.
Yes, yes. Okay, no, that's fine.
Thank you, Chair. Now, you then took over as acting group CEO for some time and later became the fully fledged group's chief executive officer. Is that correct?
Correct.
Now,
I see.
the Commissioners heard evidence about the departure of Mr. Saluji and the departure of Mr. Mshlontlo, as well as the company secretary, Ms. Africa. And is it correct that all three of them were initially charged in a disciplinary process?
I think correct, because why would they depart? Yes, the master
Yes.
didn't charge.
And
I think they were suspended, and I assume they were charged. You must be told the reason why you suspended.
well, when you say you think they were suspended at the very board meeting before you were brought in to be made acting group CEO, not so?
Correct.
Yes. And I don't know if you heard the evidence of Mr. Mshlontlo the other day, but he gave evidence that despite the three executives concerned being on suspension, they were keen to have the disciplinary process run its course so that they could clear their names. But in fact, the disciplinary process over about a year didn't actually eventually ever take place.
Correct, I heard him saying that.
Yes. Now, the suggestion has been made to this commission that Denel had no basis to charge them. It was actually just to get them out of the way because they were being difficult, as it were, in relation to particular transactions.
I cannot attest to that. If that is their view, I accept it. I cannot change their view.
What is your own perspective? Can you deny that? Effectively, what they seem to be saying to the chairperson is that the disciplinary process was in bad faith. It was a way simply of getting rid of them, where you didn't have any real substance to the charges, and that explains why it took so long. It took about a year before they resigned.
Well, you said, Mr. Kennedy, I think he didn't make the decision to suspend, nor the decision to charge.
No, with respect, that is so. So let me correct it here. I apologize if I put things wrongly. I accept that you didn't suspend, But what I'm interested in is while you were acting Group Chief Executive Officer in Mr. Saluji's place, your organization took a very long time to actually get to the point where it would start with disciplining. And that was despite the fact that these employees kept on asking, we want documents to be able to prepare so that our senior counsel can prepare, and we also want the thing to move quickly. And yet, Denel seems to have taken a long time, and the allegation has been made that that was in bad faith, that in fact you knew as management at Denel that there wasn't any serious basis for the charges, and this was all just a strategy to try and get rid of them by basically hanging over their heads the threat of disciplinary action, which never took place. How do you react to that allegation?
Chair, firstly, they were not charged by management. They were charged by the board.
I'm sorry, there were no charges?
They were not charged by management, Denel management. They were charged by the board of Denel.
By the board.
Secondly, how long it took, it was out of my control. The board was driving the process.
You had no role to play in.
The only role I had to play was to keep the documents. I still have I even left it there.
Yes.
The files.
Yeah.
That's the only role I played, if I remember.
Okay. So the whole process was handled by the board itself?
Yes, correct.
Yes. Okay. In particular, the chairperson?
Well, I think the chairperson has had a large input to it.
Yes.
Yes, but I think the other board members also were involved.
Okay.
Yes.
Did you sit at the board meetings where this was discussed as acting group CEO?
I think whenever they came to an issue regarding the suspended employees, we were asked to go outside. I do not remember sitting in any meeting that dealt with the charges.
Are you saying then that you cannot help the Commission with your own personal knowledge of facts as to why the disciplinary process took so long?
Yes, correct. I'm saying that I cannot, because I was mainly involved in keeping the documentation.
Okay.
I was not involved in conducting the disciplinary process.
Now, were you involved in the settlement negotiations?
Sorry, I didn't hear you. I see.
Were you involved in the settlement negotiations? That's the negotiations to reach
No,
a
I was not
settlement
involved
with
in
the
it.
three. Not at all.
Not at all.
Including on what amounts of money should be offered to them. Were you not? Did the board not involve you on that?
I was not involved.
Okay.
Sure.
Now, Mr. Mshlontlo was one of those suspended as Group CFO. He was he was replaced in an acting capacity by Mr. Odwa Mshwana.
Yes.
Yes. And are you aware that Mr. Mshwana contacted Mr. Mshlontlo and arranged a meeting where a mandate was conveyed to him as the mandate to settle, and in fact a settlement was ultimately reached with Mr. Mshlontlo?
I'm not aware of the particular meeting whereby where they discussed the settlement, but I was aware that because it involved finance or something, if there was going to be a settlement, that Mr. Odom Mshwana will be involved.
Do you know where he got this mandate from?
I would believe from the board.
Did he not discuss it with you?
Not in particular.
Not?
Not in particular.
Not in particular?
Yeah.
Does that mean a yes or a no? Did
No.
he discuss it with you or not?
No.
Okay. Doesn't it seem strange that he would not have discussed that with you? A settlement that would secure the resignation or termination of employment on agreed terms with 3 senior executives?
I'm not sure if it's strange, Chair, but this is what happened. And I cannot blame him for not discussing with me, but the point is he did not discuss with me. I didn't even know how much the settlement was. In fact, it was the first time I heard about it.
Well, I certainly would have expected that the board or its chairperson would talk to you about what was being done to expedite the disciplinary process against the 3 executives, because as Group CEO, you would be concerned about a situation where 3 senior executives are on suspension for a long time. You have got to have acting people. That's not an ideal situation where
Totally not.
that's going to take too long. One, I would have expected the board to talk to you about that. But I would also have expected the board to talk to you about their idea that the 3 executives should be given settlement offers so that they go, because you were the group CEO, albeit acting. You had to have the interests of the whole organization at heart. If senior executives are sought to be allowed to go, one would have thought that the board would talk to you about that and hear what you may have to say.
As I've said, Chair, I kept the documentation.
Yes, but they never spoke to you about
But in
it.
terms of having a meeting and discussing all these matters in relation to the suspension,
Yes.
I did not have any particular meeting.
Were you only informed by the board after the settlement agreements had been reached with the 3, or with each one as they got to reach agreement with them?
I think it was mentioned in one of the board meetings that...
After it had happened?
Yes.
Yes. Okay, Mr. Kennedy.
Is that, thank you, Chair, is that after the settlement agreements had been reached with the 3 individuals?
For me, my first time...
The first time you were aware?
That it was in one of the board meetings that there has been a settlement.
And so the agreements were already finalized, were they?
I would believe that they were finalized, and that's why there was a settlement.
And were the agreements, to your knowledge, signed by Mr. Mansa?
I wouldn't know.
You wouldn't know?
Because I did not see them.
Okay. Can I take you, please, to another bundle? It's bundle number 7, and perhaps your registrar, Chair, could assist us again. Bundle 7. You can just find it. It should be, yes, you're going to be helped there, Mr. Ntshepe. So, Chair, it will be bundle 7, page 741. In fact, perhaps we can start at the beginning. It's page 724. Do you have 724, Mr. Ntshepe?
724.
I can look at
Yes.
the black numbers on the left-hand corner, top left-hand corner of the page.
Yes.
Page 724 appears to be the first page of a termination of employment agreement between Denel and Mr. Mshlontlo. Correct?
Yes.
Is that correct?
Yes, I see my signature.
Yes, can you just answer one question at a time? That's going to be my next question. Page 741. You found where I was going with this line of questioning. Yes, indeed. It bears your signature. You just told the chair a moment ago that you only found out after the agreements had been finalized and signed, you believe by Mr. Mshlontlo, that it had all been finalized. And yet we see at page 741 your signature and your name.
Yes.
As acting general, group CEO. So was your evidence a moment ago incorrect?
I wouldn't say it's incorrect. I mean, if I would not remember in details this document, but I'm sure I was required to, as an acting GCEO,
Yes,
to sign this document.
Yes, but I understand. We can see for ourselves. You're not suggesting that this is a fabrication, is it?
No, I'm not suggesting.
Yes. Okay, so if
it was not even created by.
If we accept that it's not that it is a genuine document that was signed by you, your evidence earlier that you were only informed after the agreements had been finalized and signed, you believed by Mr. Mancha, that can't be correct. In fact, you can see that it was signed by yourself. Is that correct?
Yes, I did not. I said I don't remember. I'm not sure who signed them.
Yes.
Yes.
But it turns out
it turns out that it's me.
Yes.
Yes. So I'm not. I'm not now. It's my signature. So I'm not saying that it's not my signature.
Right. And sorry, Mr. Ntshepe, what?
This is 2016. So I would not remember this thing in detail.
I understand that.
Documents and whatever. Which documents I've signed.
Yes, I understand that, Mr. Ntshepe. So I'm just simply asking you if it's appropriate to correct your earlier evidence that you only heard after the event that the agreements had been signed by somebody.
Or by somebody else?
Yes.
Oh, no.
Somebody else, as I understand.
I correct that.
You correct that?
Yes.
Okay, thank you.
Well, do you remember whether you signed only this settlement agreement relating to Mr. Mshlontlo, or whether you signed each one of the settlement agreements involving the other two executives?
Chair, I have to check. Because it's such a long time. That's why I gave the answer I gave you, because I honestly.
Yes. Well, I'm a little surprised by you saying you don't remember. I would have thought that the suspension and departure of these three senior executives from Denel was something quite important, and I think it made
news.
It made news. It was in the public domain, and so on. I would have thought that if you were the one who signed the settlement agreements, you wouldn't not remember that.
Remember the settlement?
You would not forget that you are the one who signed the settlement agreements relating to this, because it would have been something quite momentous at the time.
I am not lying, Chair. I did not remember until I saw this.
Yes.
I used to sign a lot of documents.
Yes.
Yes. So it's my signature. I do not deny.
Is it possible that when you said earlier on, you were not involved at all in the processes relating to the disciplinary process, relating to these executives, the disciplinary process relating to these executives? When you say you were not involved, and when you said the board never spoke to you, and when you said the acting financial director didn't speak to you about the settlement negotiations or the settlement offers, is it possible that you might be mistaken about that, and that you might have been involved?
With this now,
yes,
it could be.
It could be.
Yes.
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 Yes. Yeah, because it just sounds strange to me that the board, you were the person that the board identified as the right person to act in the most senior executive position.
Yes.
That must mean they had confidence in you,
Yes.
you know. So it just would seem strange if they would not keep you informed as to what was happening
Can
with the disciplinary process that was taking so long. And even when they were thinking of effectively getting rid of these executives, that they would not have a discussion with you to say, look, this is what we are thinking, and maybe get your views, because you might say, well, with regard to the CEO, you can make your own decision, but I think these other two are good members of the management team. I would like them to remain, you know, whatever. Or you could have whatever views, including about the CEO.
Okay. Maybe I just answered that question
Yeah.
very quickly. Let me just come back to it.
Yes. Yeah.
My involvement was keeping the documentation, and I think to a limited extent to the administration, the lawyers, which related to the documentation. And then if I remember, and then the rest of the negotiating and the negotiations with this, with the employees. In fact, it hit me very hard. This suspension. It hit me very hard. These suspensions.
The suspensions.
Yes.
Yes.
In fact, yes, and but I was asked to act, and I believe my responsibility had to do with the company, the matters relating to my seniors, because they were my, although
Yes.
we were colleagues, but Riaz was my senior.
Yes.
And we worked very closely, very, very closely. In fact, this even affected the relationship we had.
Yes.
Yes, which is very sad for me. So when that happened, you know, I had to make a choice and say, I focus in the work that I've been doing, and I'm doing this work. And I think to a certain extent, if I remember then, it's 2016, in terms of lawyers that they are doing their work or where we keep the documents, that I was involved in. But in the detail of the actual disciplinary itself, where they met, or I've never been there, I don't even know where that was, so I was not involved.
Okay, right. Can you attend to the aircon? It's maybe if it wouldn't make such a loud noise. Okay, Mr. Kennedy.
Thank you, Chair. So as I understand your evidence, you weren't involved in the negotiations
For the segment?
for settlement,
No, I was not.
and you weren't involved in giving instructions to the lawyers or to any of your colleagues in relation to the settlement negotiation.
The money, no, I was not involved.
And you weren't involved in discussing, let alone giving your views on the possible offers to be made or the acceptance of the offers to be made with the board members.
No, I was not involved.
Yeah. Now, I appreciate your evidence that you can't recall, you couldn't recall until I showed you your signature signing this agreement. So I can't ask specifically whether you read this agreement. Well, perhaps I can. Now that you remember, because you've been shown the page where you signed that, can you remember whether you looked through this agreement?
In fact, the reason why I can't even remember that I signed it, because as I say, I signed many documents. I don't believe I read this document. I don't even know what settlement it came into.
Mr. Ntshepe, you wouldn't have signed an agreement without reading it, would you? Would you have done that? I
trust the individual sometimes who brings me the document to have brought the document in good faith and they understand exactly what's in it. And the reason that they are asking me to sign is more procedural than for me to understand exactly what is in it.
No, hang on, Mr. Ntshepe. You can't be serious with that. An agreement is something very serious.
Yes.
As a colleague says, here's an agreement, sign. You won't read it, you'll just sign because you trust your colleague?
This agreement in particular, I do not remember reading it, the settlement agreement. I'm being honest.
Yes.
Yes.
Sure. That's dangerous. Mr. Kennedy?
Does that perhaps explain why you understood that the contents of the memorandum of understanding were the same as the contents of the memorandum of agreement in the
No, I read
VRLs?
that one.
You read those?
Yeah.
Okay.
I mean, what worries me, Mr. Ntshepe, is, I mean, as it happens, I think with regard to Mr. Mhlonhlo, he was, what you were signing was that the company would pay him 24 months or an amount equivalent to 24 months salary plus other amounts. But if you were not, if you were prepared to sign without reading, it could have been any amount that you could have been signing, entering into an agreement with. You could have been signing an agreement that said he was going to be given 100 million.
Chair, I don't believe the people I was working with, especially Mr. Mhlwana, that he would have been devious to do that to me. I'm being honest.
But they might have thought it was fine, but you would have thought it was not fine.
Yes,
They might have thought there was nothing wrong in offering Mr. Mhlonhlo, for example, 100 million rand. So they would have thought, well, it's fair. He has been around in this company for X number of years, and we have no proof that he has done anything wrong. So 100 million rand is fine. But if you had read and you came across the clause which says he must be given that amount, you would have said, no, but I'm not prepared to sign. I think this is wrong. But if you don't read, you won't know that. You might discover when it's too late that you have signed something that you shouldn't have signed, and you have committed the company to huge financial commitments.
I take your point, Chair.
Mr. Kennedy.
May I ask you, Mr. Ntshepe, I know you can't recall, and it's not fair to expect you to recall every single fact, but as the Chair has pointed out, this was quite a momentous situation. It wasn't just a routine one of many hundreds of documents that you would have to sign from time to time. These were colleagues that were now leaving the employer. You say that even their suspension had caused you some anxiety and pain. You were now going to lose from the permanent employer of Denel its group CEO, whom you would now replace, Mr. Saluji, and you would lose the group CFO, Mr. Mhlonhlo, who you must have worked with closely, not so? As well as Miss Africa. Does the same apply? Sorry, you nodded. Can you just confirm in the record you worked for some time with Mr. Mhlonhlo?
Yes, correct.
And his departure or his suspension also pained you, is that right?
Correct.
And did the same apply to Miss Africa?
Correct.
Now, do you recall who this official was who came with the document asking you to sign it?
I think it was finance.
It was finance?
Yes.
Can you remember who in finance?
I would think the CFO, but I cannot totally confirm that.
The acting CFO at that time was Mr. Mhlwana.
Yes.
Yes, and he, of course, would now be replaced he would now replace Mr. Mhlonhlo, not so?
Correct.
Yes. Now, did he tell you, even if you didn't read the document, did he tell you, boss, I'd like you to please sign this agreement because the board wants you to. You don't need to read it, but I can tell you what it's about.
Well,
He must have told you for you to be able to trust him, surely.
Yes, I think he did, but I'm assuming that he did, but I cannot recall in detail that this is what he said, because I'll be able to answer you in a precise manner to say this is what he said.
Well, I'd like to
But I'm
ask...
sure he did say something. I mean, I would not sign a document without him briefing me.
Yes.
Yeah.
And do you recall if he told you what amount would be paid, or what the package would be in terms of the agreement?
Say 2 years?
Yes, it's actually 2 years, 24 months, as the chair has pointed out. Did he tell you that when you were signing this, you were committing the organization by your signature on behalf of Denel to settle with Mr. Mshlontlo for 6.6 odd million rand, equivalent to 24 months, in addition to an incentive bonus and in addition to the extra month that would still be worked out until the notice period? Did he tell you that this is what it was going to cost your organization, Denel, if you signed this?
He might have told me, but I don't remember.
He might have told you?
But I do not
You
remember.
don't remember?
Yes. Yeah.
Well, when you add the other amounts, I think Mr. Mshlontlo said the amount comes to about 9 million altogether, but the ex gratia part was for the equivalent of his 2 years' salary, which translated to about 6 million rand. 6 million rand something. That's what you were signing, committing the company to. And then included in the other amounts, in addition to the 6 million, was an incentive bonus. And I asked him the question whether the policies or rules were to the effect that you get an incentive bonus if you are recognized as having done your job well. He said yes.
Correct.
You accept that?
Yes.
Yeah. Mr. Kennedy.
Thank you. But in this case, Mr. Ntshepe, Mr. Mshlontlo had not done either well or badly in his job for the past year, almost, because he'd been suspended during that period. Yet he was paid a further, I believe it was 1.6 million rand. If you look at clause 11 on page 731, it was amounting to 1,656,411 rand. That's in addition to the 6.625 million that he would be paid, as the chairperson has pointed out, as an ex gratia payment. So the bonus seems to have been called a bonus, even though it wouldn't have been an incentive for anything, because he was now leaving and where he had not worked for the past year.
No, he did work up till he did work up till September.
Up to September.
Yeah, because the year starts in April up till September.
But this wasn't.
It wasn't pro rata, was it? Well, does it get calculated
I think it's
according to the financial year? Or calendar year?
Yeah, according to the performance in that financial year.
In that financial year?
Yeah.
You see, now they were suspended in September 2015. That would have been about 6 months before that financial year ended. But the payment was happening, I think, in about August of 2016 in regard to Mr. Mshlontlo. And from the beginning of that financial year, in April up to August, he had not worked because he was on suspension.
Correct.
So in regard to the previous financial year, it's about 6 months that he had not worked. That is the 2015-2016 financial year. In regard to the 2016-2017 financial year, he had not worked for 8 months before, for about 6 months before he left. So in each financial year, he had not worked for 6 months or so.
Correct.
Okay.
In fact, Chair, if I may
Yes.
draw the attention of the witness to clause 11 at the end, which in fact seems to clarify the point at which it was to be paid. It says he would be payable at the same time as with the rest of the employees no later than 31st of October 2016.
Oh, okay.
Mr. Ntshepe, what I'd like to put to you is that it seems highly improbable that you would have been unaware of at least the ballpark figure that was to be paid to Mr. Mhlonhlo in terms of the settlement. Firstly, because it would have been reckless for you as Group CEO to sign anything that was committing the organization to substantial amounts without knowing what they are. The Chair has already asked you that question. Do you want to add anything to what you've said?
What I'm saying, Chair, is that I think Mr. Odo, I cannot confirm Odo Mhlana would have...
I'm sorry, just repeat that.
I think Mr. Odo Mhlana, who was the acting CFO, might have briefed me about this document. And in terms of the amounts, I do not remember, I have to be honest. Yes, I do not remember exactly what amounts the settlement was. And I believed, because of the position where I was sitting, it was necessary for me to sign this document as tabulated here, because it would have had to be signed at the highest level in the organization. But the exact amount of the settlement, I cannot vouch to that I know exactly what the amount is.
Yes, my question was phrased deliberately on the basis that you would at least have known what the ballpark figure was. Maybe not the exact rands and cents, but that you would have known that it would have been 24 months equivalent, and you would have known how much Mr. Mhlonhlo was earning, not so? Roughly.
Yes, he was. Yes, I knew. Yeah. I wouldn't know roughly. I wouldn't know. Yes, yeah.
Yes, and you would have known also that he was getting the other benefits. And I put it to you that not only must you have found that out, because it would have been reckless for you to sign it otherwise, but secondly, isn't it a matter of simple human nature that you, as a colleague of these individuals who are now leaving, you've been anxious when they were suspended. They've now been facing a disciplinary process which never gets to the point that it actually starts, let alone concludes. You are paying, you as acting GCEO were allowing the organization to pay them during this period of extended suspension, not so? Correct?
Not me as such that's paying. I believe that because the ultimate accountability of the organization is the board. The board was paying them this money.
Yes, but you were aware that they were being paid during this period by Denel.
I knew there was a settlement, but I...
No, Mr. Ntshepe, we're at cross purposes. I'm sorry to interrupt. I don't mean to be rude. I'm talking about the payment while they were being suspended, while they were on suspension. You must have known that they were being suspended on full pay.
Yes, that
yes. So you knew that this process that you weren't involved in, the decision to suspend them, or the decision to pay them during suspension, or to negotiate a settlement, you were on the sidelines because the board was deciding that, and you gave no input according to your evidence.
The input, I never gave an input in terms of firstly the settlement. I never gave an input in terms of the disciplinary process itself. Yes.
I'm summarizing what you've said about this already. We don't need to go over that again if you don't mind. So, but what I'm saying to you now, surely it is significant, as the chair was suggesting to you earlier, it must have been significant to you, whether as GCEO in your official capacity or even just in your normal human capacity as an individual. You must have thought, wow, I'm glad to hear that the board has resolved this with Mr. Mhlonhlo. Did you feel that?
Yes, I'm not sure if I was glad, but because...
But you were aware that they were reaching the settlement?
There was a settlement, because there was an end of the The whole process.
Yes.
Yes.
This cloud that was hanging over
Yes,
Denel's
yes, there was-
executive team
yes, yes.
was now being resolved, correct?
Yes, there was
Yes.
a settlement.
And money was going to be paid to Mr. Mhlonhlo. Surely just at the level of human curiosity, let alone as group chief executive, you would have been curious to know, is Mr. Mhlonhlo going to leave without any pay? Or is he going to be paid a package? And what is it? How much is he going to get paid? Maybe not down to the rands and cents, but roughly how much?
Being honest, I mean, even as group executive or as a chief executive or as a human being. I mean,
Both.
I trusted that the CFO, whatever he put and agreed on the settlement with the board is genuine enough. It's not an issue whereby I should come and interfere. I believe it was genuine enough.
Are you saying you saw the figures, or you were told by Mr. Mr. Mshwana, the ballpark figure that was going to be paid, and you didn't interfere?
I have to be honest. I do not remember.
You do not remember?
Yes.
Okay.
Yes.
All right, thank you. May I just...
Well,
Sorry, Chair. After you, please.
okay. Did you ever form a view as to whether the board's decision to suspend these 3 executives was justified or fair? Did you ever form a view on that issue before they left, the 3 executives left?
Chair, with respect and with respect for the people who were involved, can you allow me not to answer that question?
Well, I don't know if I will allow you, but let me ask you another question. Did you ever form a view whether it was justified, the board was justified in giving them the amounts of money that it gave them effectively to get rid of them? Because I don't think it's anything
I formed
else
a
other
view
than
in
that.
terms of the process being completed.
Please just start again.
Chair, I formed a view for the process being completed. That now we can, it's either I...
You formed a view after.
Yes, yes.
Yes.
The process has been completed.
Yes.
I say largely I was not involved directly into the process of the suspension because I could have been conflicted because they were my colleagues, they were very close with me, and that would be left to the board to decide how they're going to execute that action. However, I was in a sense, as I say, a custodian of the documentation, of all the documentation that was involved. Forming a view about the fairness or the unfairness of the suspension.
No, I will allow you not
Yes,
to express
please.
a view on the suspension, but I think I would want to find out whether you formed a view or not on whether the board was justified in paying out the amounts that it paid out to them to effectively get rid of them.
Now that I know, no, it's too much.
You thought it was too much?
Now that I know.
Now, yes.
Yeah, yes.
Yes, but at that time, did you have a view or whether the board was justified in paying so much money in order to get rid of them?
Usually, if I think an executive leaves who has a 5-year contract, It's either you buy him out. So this could have been a process of buying the executives out. Yes, the amounts. But if it was just an ex gratia amount to get rid of them, I don't think that would have been the correct justification. But if you're buying out the contract because you have a contract with the individual, I think that is a procedure which happens in other organizations. So I would not have opposed that view.
But of course, even if you are talking about buying out a contract, which effectively means if you had a 5-year contract with us,
yes,
and after you have worked for 1 year, we don't want you anymore, we say we'll pay you for the balance of the period. You know, but even on that, it would be necessary, would it not be, to make an assessment whether it's justified, because it might be a lot of money that you are going to spend, not your money, company's money.
Yes. Mr. Mtlanto was, I don't want to say it in public how much he was earning. He was earning money equivalent for 2 years, equivalent to the money which was paid out.
Yeah.
Yes.
Yes, but what I'm saying is the fact that a company or a board might resort to what you call buying out, that on its own, it doesn't indicate that it's justified or not justified. It depends on what the reasons are and so on, isn't it?
Correct.
So then I go back to this, this question. You being the person that was asked to sign the settlement agreement, was it not your duty to satisfy yourself whether it was justified to enter into these settlement agreements with these terms, including the amounts to be paid to them? Because in the end, even though the decision may have come from the board, I take it that as Group CEO, as the person who was required to sign, you would have been entitled, if you thought that this was wasteful expenditure or something like that, to say, I'm not signing. It's not in the interest of the company that such large amounts being paid in these circumstances. I'm not prepared to append my signature.
Chair, as I said, in Mr. Mtlontlo's case, the ballpark amount which I've been told is within his salary. And I will have to find out what the others
yes.
paid.
Yes.
And in terms of his bonus, I think I did not see anything wrong. Or do I see anything wrong for him to get a bonus for the time that he worked?
Yes, but the ex gratia?
Ex gratia?
24 months salary for him to leave.
Well, is that ex gratia or is it a buying?
Called it ex gratia in the settlement agreement.
Yeah, but for
in the settlement agreement that you signed.
Yeah, it is buying out what I'm sure the contract was left.
It was not the balance of his contract.
It was not?
Yeah, his contract was, he said what was left was something like 30 months, and what they gave him was the 24 months meant that he lost out about 6 months.
Yes.
Yeah.
Yes. The question.
So my question is whether you don't accept that you had a duty in regard to whatever settlement agreements you signed as Group CEO to satisfy yourself that this was justified, because otherwise you could be committing the company to pay an amount, to make payments that would be fruitless expenditure.
It is correct, Chair, and as you have explained the amount,
Yeah.
though they might call it ex gratia, in my mind, it's buying out of the contract. You say it is 30 months, and they paid it for 24 months.
But you would have to have proper reasons for wanting to buy out an employee, isn't it? You can't just buy out an employee as you please.
Yes,
There
I'm
must
sure-
be proper
I'm sure you would
reasons.
I'm sure you would, yes.
Yes. So my question goes to exactly that, whether you didn't think it was part of your duty to satisfy yourself that you were signing something you could defend.
Yeah, the issue,
Namely, were there proper reasons for this to be done by the board?
Chair, that matter, as Mr. Mhlonto indicated, was taking a long time to be resolved. And not only that, it was affecting the organization because it was in the news almost every day. And that matter needed to be closed. And to me, those were very strong reasons to say, we need to resolve this matter. And if we buy out the contract that is of Mr. Mhlonto, in the end, though it is called ex gratia here, I have no objection because I think it would have been a matter of resolving the matter, the issue, and I would not even think that it's a wasteful expenditure because in essence he's contracted for the next 30 months.
Well, I'm not sure that that's a proper answer because what if the right thing to do, which is in the best interest of the company, is to allow them to come back if the company can't put up charges against them? They were suspended on the basis that they were going to face disciplinary charges. Why did it take, why was it taking so long if there were proper grounds for them to be charged? If there were proper grounds for them to be suspended in the first place? So, didn't that indicate that there were no proper grounds for them to have been suspended in the first place? Didn't that indicate that there were no proper grounds to sustain the charges? Because otherwise you just call them to a disciplinary hearing, they face the charges. If they are found guilty and they are dismissed, that's it. If they are found not guilty, they resume their work, that's it. Why must there be a payment of millions of money to them without determining whether they are guilty of the allegations that are made against them?
Chair, the ultimate decision to pay them out, it did not come from me.
No, I understand
yes.
that.
The matter to say that they should come back or not come back, it was out of my, can I say jurisdiction? I'm not sure if it's...
But wouldn't you be able to say, if you took the trouble to look at the matter and say, why is the company reaching a point where it must pay out such amounts? And you ask yourself, where is the justification? We were told they were being suspended to face disciplinary hearing. Why are they not facing disciplinary hearings? I'm not going to sign if this is being used illegitimately instead of letting them face a hearing and let them be found guilty or innocent.
Chair, I'm not sure if that is totally true that they did not face any hearing.
Well, there was no hearing. That's the evidence I've had. There were charges that were formulated and sent to them, and Mr. Mhlonto has testified, and Mr. Saluji testified last year that they were keen to face the charges, and there is correspondence from their attorneys to the attorneys of the board where they were saying, we are ready, we actually want the charges, we want the hearing, we want to clear our names. And at some stage the board, instead of agreeing to that, said, no, let's have a mediation. They agreed, but what they wanted, they have testified, is a disciplinary hearing where they would be cleared. Actually, if I remember correctly, when Mr. Mhlonhlo was testifying, he even said, even though he took the settlement, the amount, he signed the settlement, he was still concerned that in the public domain, his name had not been cleared because Denel had publicly said certain things about them when they were suspended and I think when they departed.
Yes, I hear you, Chair, what you're saying.
Yes.
But I don't think it's totally...
But you don't think that you would have refused to sign if you didn't agree that they should be made, given those amounts to leave? You think as long as the board made that decision, you would have gone along?
Yes, I would have gone along.
Yes. Okay, Mr. Kennedy.
Thank you, Chair. May I just in conclusion on this point, Chair, ask the witnesses, you've given evidence earlier in relation to Ms. Malashlela to the effect that if she had a different view to her colleagues about non-compliance with procurement and whether the jobs should have been done in-house, you felt that it was obligatory, that it was required of her that she should have recorded this and brought it to the attention of her superiors or even the Ministry of Public Enterprises. Why does the same not apply to you? If you have now expressed the view that you think that the ex gratia payment of 6.6 million of public funds at a time when Denel was not in a healthy financial state, was it not incumbent on you to have drawn to at least the attention of the board, let alone the minister, that you felt that this was too much, this was inappropriate? And as the chairperson has pointed out, if there's substance to the charges, let the process run and let it run quickly. If there's not substance to the charges, drop the charges and let them resume their jobs. Wasn't it incumbent on you to express any concerns you had, or are you saying you didn't have concerns?
Chair, the amounts that have been, the one that I've been quoted in, for me, it looks like it was the buying out of the contracts. And the board was very much aware of the whole process, what is happening. And for me to go along with the board as an acting, in fact, I was not even a board member then. I was acting, and they have charged me with this responsibility. I believe the board took their decision to say let them settle, and my job was to run the company, not deal with the...
But your job, running the company, includes running the company properly, and it's not running the company properly if you are going to pay millions of the company's money to people when there is no justification, and you don't even want to find out whether there is justification. Running the company properly includes making sure that whatever decisions you make, including signing a settlement agreement with an executive to leave, that you know that there are proper grounds. It doesn't mean just going along with what the board says. Actually, as Group CEO, as far as I'm concerned, you are supposed to be able to take a view on certain issues, even if it means disagreeing with the board, and say, I don't agree. That's what is required when you are CEO.
Yes.
And therefore, in terms of these, I'm surprised that you don't seem to, these settlement agreements, you don't seem to have taken the trouble even to read the settlement agreements, to see whether the terms of the settlement agreements were such that you would be comfortable to append your signature to the settlement agreements. It seems that you took the view that whatever the board wants, I will facilitate, I'll sign.
As I said,
I don't think that's a proper approach or attitude of a group CEO.
As I said, Chair, my job was to act as an acting GCEO at that point in time. The settlements I was not involved in, firstly in negotiating them. I think Mr. Mhlonhlo said that. I mean, he met with Mr. Odwa Mhlwana. And secondly, I fully trusted our CFO that he will do the correct and he will know exactly what is it that he's settling on. And from what you are telling me is that actually it's within the ballpark of what I would have expected him to pay. I mean, in terms of the 30 months that he still had the contract with, notwithstanding his salary, how much he was earning per year, and the bonus that because he did work, I think 6 months or so, and I think if it's 1 point something, it was prorated. I'm not sure. I think it was prorated. I would not remember the details. Yeah, but I do not find any anomaly in saying that the settlement came to these amounts. I mean, senior executives in organizations, they earn salaries whereby when you have to buy out somebody's contract, the amount is huge.
Well, let's leave out the issue of buying out, Mr. Ntshepe, because the settlement agreement is here,
Yes.
and it doesn't talk about buying out. It talks about an ex gratia payment.
Yes.
The board decided that they should get ex gratia payments. Actually, on the basis of this settlement, on the basis of the fact that you are the one who signed the settlement agreement, one would be entitled to say you are the one who decided to give Mr. Mhlonhlo an ex gratia payment of so much, because that's where your signature is. So, but I'm focusing on your approach or attitude towards the board and the signing of the settlement agreement. And I'm saying it's a bad thing for a CEO of a company to sign a settlement agreement without reading it, number one. Number two, I am saying it's a bad thing for a CEO of a company to sign such an agreement to effectively get rid of executives without satisfying himself whether there were proper grounds for getting rid of the executives, because effectively these amounts were paid so that they could go. I'm suggesting to you that a CEO who looks after the interests of the company would want to satisfy himself whether there are proper grounds. Because if there were not proper grounds, and if it seemed to him that it was not in the interest of the company to enter into this transaction or to this settlement because there are no proper grounds, he would be duty-bound to say to the board, this is wrong, this is not in the interest of the company, and I'm not prepared to sign the settlement agreement. Do you want to comment on that?
My comment, Chair, would basically say that the circumstances at that time were very difficult in Denel, whereby we needed to move forward than standing still and having a lot of noise around Denel at that point in time. If and when the negotiations came to the issue of settlement, I did not oppose it. And once the settlement amount has been calculated, that was, to me, that was the responsibility of finance. Because especially the financial director. And from the figures that you are telling me, or the SC is telling me, it's within the ballpark. It's not an irresponsible amount. I mean, 6.6 from what...
But that's part of my concern, Mr. Ntshepe. You seem to keep on wanting to look at how much only. Whereas, although that's a factor, I'm saying the first thing is you have to satisfy yourself whether getting rid of these executives is the right thing, are there proper grounds? Because if there are no proper grounds, it might not be in the interest of the company to get rid of them?
We're coming back to the issue of saying, basically the opinion to ask me, did I think it was a correct thing to suspend them or not?
No, it's different. You remember I asked you
Yes.
two questions,
Yes.
two opinions on two issues.
Yes.
First, it was whether the suspension were fair,
Yes.
and then it was whether it was justified to get rid of them and get them paid the amounts that they were paid.
Yeah.
And I said, with regard to whether the suspensions were fair, I'm quite happy not to insist that you give your opinion. But I said, with regard to the other one, I would like your opinion. And basically, that's because you were the person signing, and therefore signing the settlement agreement, and therefore committing the company to paying millions of money. And I was saying to you, before you could do that, you would be expected to see whether there are proper grounds to do this, because otherwise you would be doing something that you shouldn't be doing.
Yes. I think we are going to go around the circle, Chair, because I'm going to say again that there was a lot of noise in the system.
Oh, okay. Well,
Yes.
I remember what you said about
Yes.
noise.
Yes.
That's your justification.
And the point is, we needed Denel to move forward.
Yes.
Yes.
Yeah. Okay. No. On that, I think we don't have to go back. That's what you advanced to justify signing the settlement agreement, and not looking into whether there were proper grounds to get rid of the executives or not.
I don't think I had the mandate to look at that, Chair.
You didn't think it was your place,
Within my scope of work,
Yes.
if there are proper grounds or not.
even if you would be the one to account, because I guess you were the accounting officer, were you not? As group CEO,
The accounting
officer.
Is the board.
There is accounting authority and accounting officer,
Yeah.
isn't it?
Yeah.
Yes. Were you not the accounting officer and the board
Yes.
accounting authority?
Yes, because I represented the board into the company.
Yes.
I would take myself as an accountant.
Okay, all right, Mr. Kennedy.
Thank you. I'd like just to touch on one last question on this, and then I just have one final brief topic about the termination of his own employment. I understand you're hesitant to express any opinions as to the grounds to justify them being paid out to leave the service. But Mr. Nhlonhlo in particular has raised as a concern, why was he being paid such a big amount if he was guilty of it, of the misconduct? Why didn't they complete the disciplinary process? And why were they so keen to get rid of him? What he has suggested, and Mr. Saluji has also hinted at this in his evidence, is that the reason why there was such a desire to get rid of them rather than to actually discipline them if they were genuinely guilty of misconduct, where was the case? Where was the evidence? So what they have suggested is that they were being removed deliberately from Denel because they were seen as an obstacle to certain transactions that later proved so controversial.
I don't agree with that, Chair.
Are you able then to express an opinion on this?
Yes, I can express an opinion.
Yes.
On what basis?
Yes. So,
There was a transaction to buy BA Systems, which later became Land Systems South Africa, which cost the company 855 million rand. And there were two banks that were involved. One was the Nedbank, and the other one, I think it was ABSA. Nedbank was given the impression that we only need a certain bridging fund amount we'll be able to pay in 6 months. And we do have the other amount is Denel money. In other words, Nedbank was going to pop out the 450 or 455, and the 400 is Denel money. Whereas the truth was, Denel did not have money. Actually, we were struggling to pay the suppliers at that point in time. So firstly, I cannot believe that the issue was that they were just got rid of because of they wanted to get rid of him because they are not doing any some things. But I think for me, that was the major issue because they could not, when it went to the board, they could not account exactly. Firstly, why would you not tell the truth, the bank, that you are also going to borrow the 400 from ABSA? You don't have the money. So you borrow 400 from ABSA, but you tell Nedbank that, no, I do have the money. And then the time that when this thing was reported, I think 250 or 55 within 2 weeks was due. And the board had it for the first time at that board meeting. I think that this thing started probably at the audit and risk. And then when it came to the board meeting, that's when the first time they had that in 2 weeks' time, Denel must pay Nedbank the 255 million. And we did not have it, or Denel did not have it. So I think that for me, in fact, I even sat with the group CEO outside the meetings because they wanted an in-camera meeting. And then we sat outside. I think we sat outside for 2 hours, and because we got along very well, we were not even thinking suspensions at the time. Whereas they were talking about this issue that the matter of the money being due in 2 weeks' time, and we don't know where we're going to get the money from.
So are you saying they've done something wrong? Therefore,
for me,
suspensions and maybe not this, but that they should face disciplinary charges, and that they should face disciplinary charges was justified because this is what you are aware of what they've done wrong. Is that what you are saying?
For me, it's telling the board in 2 weeks' time that they have to pay 255 million was a serious matter, and the money is not there.
Yes, but what I'm saying is,
and you are
suggesting that they've done something wrong.
In that particular issue, yes.
Yes, and now if they've done something wrong, why were the disciplinary charges not pressed against them and pursued?
I think they were pressed, if I remember.
No, but we have just told you that there was evidence here that there was no hearing that ultimately took place. Actually, the fact that you signed settlement agreements indicates that no hearing was concluded. Actually, they say, Mr. Mhlonhlo and Mr. Saluji say, no disciplinary hearing started in substance. There were dates when it was supposed to start, and when they arrived, the company had failed to give them documents, and there were discussion about documents, but they were ready to face the charges.
Chair, with due respect, I think there were hearings. It's not true that there might not have been a final decision-making hearing, but there were hearings.
But are you saying that there were witnesses who gave evidence in disciplinary hearings? Because we agreed that they were suspended. We agreed that they were given charges, the charge sheets. They were given that. And I've just told you that they said dates were fixed when the disciplinary hearings were supposed to proceed. But it did not proceed. And on one occasion, when it was supposed to proceed, there was an issue about documents which the company had failed to provide, or they provided documents which they couldn't make sense out of them, and the hearing did not proceed. So, are you saying that there were witnesses who gave evidence in disciplinary hearings?
I think there were hearings. Whether there were witnesses in the final or as we know, there was no final hearing whereby a decision by the company was made. But because this matter took a year, so there was not only one meeting as far as I remember.
But we're not talking about meetings. Hearings. Hearings are where witnesses give evidence.
Yes.
That's what I'm talking about.
Yes.
I'm telling you that both Mr. Mhlontlo and Mr. Saluji have testified here and said no such thing took place. So you are saying you think there were hearings. So I want to know whether you mean you are denying what they are saying, namely no witnesses gave evidence.
I beg to differ. In my understanding, there were hearings.
But do you know for sure, or did you hear from somebody? Because these were the people who were facing allegations. These are the people who would have taken part in the disciplinary hearings. They have come here and said under oath, no witnesses gave evidence. Are you saying that you are disputing what they said? Were you at those hearings?
No, I was not in those hearings.
So on what basis can you dispute what they are saying?
As I said, I was keeping the documentation.
Yes.
Yes. And the documentation did show that there were hearings whereby Mr. Mhlontlo met, I think, Denel lawyers.
Yes, don't talk about meeting. Talk about witnesses giving evidence, because meetings did happen, but not hearings. That's what they say.
Well, witnesses in this case would be the banks. I think the witnesses in this case, for me, it would be the banks, because they were the ones who were being owed the money.
Yes, but do you know whether witnesses gave evidence?
No, I do not know that one.
Yes. So I'm saying to you, therefore, why, if they're done wrong, according to what you say, why the company did not call witnesses, have a disciplinary hearing, and subject them to a hearing and make a finding, rather than paying them millions without them facing those allegations?
The final decision, Chair, was not mine.
No, I accept that it was not mine, it was not yours. But I come back to this question. If you signed this settlement agreement, certainly you signed Mr. Mhlontlo's one, to say the company will pay him 6 million rand. When you knew that, according to you, he had done something terribly wrong, how would you justify paying him? Signing the settlement to say he must be paid so much, and even saying he must be paid an incentive bonus, when you did so knowing that, as far as you were concerned, he was guilty of something serious?
I cannot judge, Chair, that he was guilty or not guilty. I'm just stating the facts as they were at that point in time.
Yes, but you say you were aware that, as far as you were concerned, they had done something wrong, and you think it was serious. And one would have thought that when an employer is aware of that, they would subject an employee to a proper disciplinary hearing rather than pay them large amounts of money when they think they have done something wrong. It doesn't...
I can speculate, if you allow me, maybe why in the end it never came into a finality in terms of disciplinary.
Well, I don't know why you want to speculate. I don't think you should speculate. If you don't know the reason, you don't know the reason.
Okay, I can leave it as saying that I don't know the reason. I don't know the final reason.
Okay, all right. Okay. Mr. Kennedy, I know we have gone beyond 1 o'clock, but I don't know how far we are from finishing with...
I think 5 minutes.
Okay, let's try and finish so that he can be released, and then when we come back, we take another witness.
Thank you, Chair. Just a final question on this point. As Group Chief Executive Officer, albeit acting at that stage, you were the accounting officer, as you confirmed earlier. In terms of the law, is it not correct that the accounting officer, yourself, was responsible to ensure proper disciplining of staff?
Of staff, yes, but not of board members.
Not of board members?
Yeah, they were board members.
Right. So are you saying that you had no responsibility to ensure that they were disciplined if they were...
Board members. Board
they
members was out of my...
Sorry, please don't interrupt while I'm putting a question. I'll give you an opportunity to answer it once I'm done.
Apology.
Just please bear in mind that when it's recorded, the poor person who has to transcribe this won't be able to work out who's saying what. So are you saying that the fact that these individuals, Mr. Saluji, Mr. Mshlontlo and Ms. Africa, were not only employees of Denel but also board members, that disabled you from disciplining them?
Yes.
Well,
I did not, if I can expand.
no, if that was your view, I
Yes.
understand it. Whether that's legally correct is perhaps something that can be argued at a later stage. Mr. Mshlontlo, I'd like now to pick up on something you mentioned earlier. You said that you were charged for not doing for allegations of not doing your duties in relation to the board. Did I hear you right?
No, I didn't.
I misheard you. You resigned from your position as Group CEO
Yes.
just shortly after the new board had come in. It's after the board under Mr. Mancha had ceased to hold office and
Correct.
a new board under Ms. Shlashla as its chairperson came in. Is that right?
Correct.
Yes. Now, Ms. Shlashla has given evidence before the Commission that you and others, in particular Mr. Mshlowana, who were implicated in allegations of wrongdoing, that was being investigated, and in fact a disciplinary process was brought against Mr. Mshlowana, who was then dismissed. Is that correct?
Correct.
Yes. But she testified that although the investigation was underway and the likelihood was that you would have been disciplined, you abruptly resigned and thereby avoided a disciplinary process.
No, it's not because I avoided the disciplinary process.
So why did you resign?
I resigned for one, personal health reasons, because by that time my blood pressure, my sugar was a mess. And I realized that I have to make a decision, but also I could see that the new board and the old board, there are huge differences, and maybe another person can come and take the leadership, especially in the GCEO position. So I don't have any other income. It was not an easy decision, but sometimes you make difficult decisions because of the circumstances.
Thank you, Chair. We have no further questions of this witness.
I need to mention something to you, Mr. Ntshepe, as part of being fair to you. Over the past two and a half or so years, I've had a lot of evidence about what has been happening in various SOEs. That includes Denel, because I had some evidence last year already in regard to Denel. One of the matters that has caught my attention, particularly of late, is the question of the type of people that should get appointed to boards of SOEs. What should South Africa look for? What type of people should be part of boards of SOEs? Because one of the questions that arises within the context of allegations of state capture, as well as high levels of corruption that has happened in various SOEs and government departments, particularly SOEs, is whether these SOEs had the right kind of people in the boards, but also the right kinds of people in senior management, such as chief executive officers and chief financial officers and chief procurement officers, those type of people. Because one is forced to ask the question, how was it possible that some of the things that have happened in SOEs, in terms of corruption and certain transactions, how was it possible for these things to happen while all of these people were there? Maybe some of them were party to some of those transactions and irregularities. Maybe some were not party, but they didn't do their job the way they should have done their job. You understand?
I hear what you're saying.
So it is within that context that in part I'm concerned about your evidence that you may have signed a settlement agreement without reading it, and that you may have just gone along with what the board said, what the board wanted, because it seems to me that group CEOs for these SOEs must be people of a certain type, and must be people who will decide this is wrong, this is right, and if it's wrong, I'm not going to allow it. And even if it comes from the board, if I think it's wrong, it's wrong. I will not be party to it. Rather than a CEO who will say, well, as long as the board wants, that's what the board wants, I'll go along. So I'm mentioning that because at least part of it emerged from your evidence and it concerns me. I don't know if you want to say anything. You might not have anything to say, but if you do want to say something, I'm giving you that chance.
Thank you, Chair. I would conclude by saying that I do admit that mistakes were made. I cannot deny that.
That's important to make that admission, because somebody who doesn't see that a mistake was made or mistakes were made makes it difficult to say, how do we resolve things? Yes. But if somebody at least is big enough to say, I can see that, yeah, we made mistakes, or I made mistakes, and I take responsibility for my mistakes and for my decisions, at least that person could contribute to saying, well, what should be done going forward to make sure that these things don't happen again? What type of people should occupy certain positions and so on? But I interrupted while you were just saying, you had just said you accept that certain mistakes were happened.
The perception, I might be wrong, okay? But the perception is that outside, and maybe with the people I've engaged with, is that though mistakes were made, does it warrant a hearing such that an individual must face the whole of South Africa and express themselves, and in a sense being exposed to how competent or incompetent that individual is? One, or could it have been there another method adopted to come to the same conclusions? I think the State Capture Commission did a fantastic job by revealing these mistakes. I would also say that it is sometimes the people who come here, especially if you are being cross-examined, you feel like a decision has already been made. It's just you fitting. You will be asked the same question 10 times until you come to a point where you are required to come to. So that's my honest opinion about this matter. But the issue of correcting the boards, yes. And it's not only in South Africa that the state-owned companies have problems with boards. Many countries, actually other countries, have even got rid of state-owned companies and privatized them. So as a growing democracy, I think we are learning. It's a learning curve where we are going and how we're going to get there. So I'm not saying that there should not have been an inquiry. The inquiry is fine. However,
there's a perception that the Commission has long made its decisions.
I'm being honest.
No.
Yes.
It's you.
Yeah.
It's a perception that gets articulated by certain people from time to time.
Yes.
You are not wrong to mention that you are aware of that perception. You are not wrong for mentioning that.
But I'm a citizen of South Africa, and I grew up in this country. I will abide by the laws of this country.
Yes.
If I'm needed here, that's why I'm here.
Yes. Well, thank you for your input, Mr. Ntshepe. We will always try the best we can to treat everyone fairly. We try.
Yes.
We are not saying that we are perfect. We are not perfect, but we'll keep on trying. But it may be that in the eyes of certain people out there, when either the evidence leaders or myself, we ask questions, certain questions, people feel uncomfortable about those questions, and that's when they think we have made up our minds.
It is true that,
you see, certainly as far as I'm concerned, some of the questions I ask is to actually not some, all of them, is to either get clarification or to get an opportunity, to give you or a witness an opportunity to give me their side of the story, their own perspective. I could sit here and listen to whatever you're saying, and in my own mind and say you're talking nonsense.
Correct.
But say nothing, ask you nothing.
Yes, correct.
And then make findings in the report which criticize you. But you never got a chance to try and influence me. Correct. So when I put questions, even what you might think as difficult questions, I'm affording you an opportunity to say to me, no, that's not the right way of looking at it. Here is the right way, at least according to me as a witness. Here is another way, and therefore influencing my thinking. But it seems that some would prefer that we just keep quiet and just write the report. So we will do everything we can to be fair to everybody, but we will not allow that to detract from our function, to try and establish the truth.
Correct.
And ask even uncomfortable questions just because people will accuse us of having made up our minds. We will do our job and we'll ask questions, but throughout we will be doing our best to be fair. And I can assure you that there is no decision that has been taken. But if you are giving evidence and I'm concerned about certain things, I'm going to ask you. And you should see that as a benefit because I'm raising with you something that might be troubling me about your evidence. And I'm giving you a chance to explain it to me. And if you explain it to me, you are giving me the benefit of your side of the story.
Correct.
You understand?
I totally agree with you, Chair.
Yes.
And I really appreciate for you
Yes.
giving me this opportunity to express myself.
Yes.
And it's a pleasure.
Yes. Yes.
Thank you.
No, thank you very much, Mr. Ntshepe, for coming to the Commission to assist the Commission. We appreciate it very much. If we should need to ask you again to come back, we will ask you. But I see that your legal representative seems to want to say something. I don't know whether he wants to re-examine. Let me find out from him.
That's what I was going to address.
Yes.
I thought the Commission would allow some form of
re-examination. No, we do allow it if you would like to re-examine. We might probably have to do it after lunch if you insist on it. But I've seen that more and more practitioners tend to ask one or two questions or say, no, I'm covered. But if you want, we will give you, because you are given that right in terms of the regulations.
Yes, I think I've got 3 questions.
Oh, well, if it's 3, I think we can take them now so that when we take the lunch break, you and your client can be released.
Okay.
Okay, all right. You may re-examine. It might be convenient if you re-examine from where you are, if that's convenient for you. But if it's not convenient, Mr. Kennedy will allow you space to do so from where he is. You'll just allow somebody to sanitize first.
Thank you, sir.
Thank you.
Mr. Ntshepe, it would appear from the last questions of my learned friend that a perception has been created to some of the witnesses who came to testify that you were chosen to replace Mr. Saluji and to be a blind CEO. Did you get that sense?
Yes, I hear you.
Were you chosen to act as a CEO and subsequently appointed a permanent CEO to favor a certain or a particular individual or an entity?
I was asked to act, and I applied for the Group CEO position I believe in a fair manner, whereby there were other applicants for the job. So for me to say that I was chosen, it will only apply when I was asked not to leave until the meeting. And that's when I found the surprise that I have to act. But to be a permanent CEO, I was not chosen. I still believe I qualified. It also was taken to cabinet.
Subsequent to your appointment as a acting GCO, is there anyone in the board who approached you and asked you to favor a certain individual or entity in your dealings at Denel?
As acting GCEO, no.
As GCEO?
As GCO, it was not a long time, Chair. And
No.
Yes.
But it didn't happen either during the
No,
short time?
it did not happen.
Okay.
In your dealings at Denel, did you endeavor to favor a particular individual or a particular entity
Of Denel or outside Denel?
outside Denel?
I did not favor any entity outside Denel. I, however, was instrumental in helping outside entities to have business with Denel or be partners with Denel. But I did not favor any. There were, as a business development and new business development, my responsibility was to create or help, I would create, but help to create partnerships with companies, especially black-owned companies, to be involved in the defense industry.
You indicated in your evidence before the chairperson that Denel had been involved in business transactions with VR Laser for quite a while. Correct?
Correct.
How long?
Yeah, as far as I remember, 2003. 2003, 2004.
And then they came Salim Issa.
Correct.
Now, the question I want to ask you is, why did you support the joint venture between Denel and VR Laser?
To me, it made sense to get into the Indian market back. Denel was bruised before. We had spent a lot of money. In fact, I think my estimate last time was an underestimate. It could have been far more than that. And for us to be able to get into the Indian market, it was difficult now because we have been out for more than 10 years in the Indian market. And it made sense to me that we should have a partner who we will share the risk because India is not an easy market. Many companies actually even folded because of the Indian market. It's not an easy market. And mitigate the risks to the holding company, which is the Denel Group. And if there is any mishap in future, because in India mishaps happened very frequently if you have a contract, a huge contract. It only and only be contained in that division. And there was also the issue of, as I have indicated, the amount of investment that VR Laser Asia was prepared to put in front.
You testified that you came to know that Salim Issa is associated with the Guptas.
Yes.
Did that knowledge have any influence on you to support VR Laser in the joint venture with Denel?
I continued as I started when I was introduced to Salim Issa, and who he associated with, I separated that from the interaction which I was required, as it was indicated that I was expected to maintain the relationship. But I cannot deny that he was associated with the Guptas.
Was there any financial benefit that flowed between Denel and VR Laser?
Funding benefit. There was delivery of products. For instance, the Caspers, about 45 Caspers to, Chair, if you allow me, I cannot mention other countries because it's very difficult in this environment, because it can be a serious issue for the country, whereby all those Caspers were manufactured by, especially the hulls, but the final assembly in terms of the integration, the radios and all that was done by Denel or other suppliers. So there was benefit for Denel that we were able to meet our contract. Then there was benefit for, I think, via laser in terms of, I'm talking via laser South Africa, not Asia. In Asia, there was no benefit at all. But via laser South Africa, there was benefit for them because it was revenue for them.
Okay. Well, if you are not done, we'll have to adjourn. You said 3 questions. I think you are approaching 10, if I'm not mistaken.
I'm almost there, Chair.
Yeah?
I'm almost there.
Well, you are going to tell me 1 and it will end up being 3. If you have 1 more, then I'll allow you to ask that one, then we can adjourn. But if you have got more, I think we should adjourn, and then your punishment will be to have to wait and come back after lunch.
Chair, can you ask 2, Chair, then?
Okay, all right.
Thank you, Chair.
Strictly 2.
So, we are referring to the time when, starting from 2003.
Yes.
Would you say you have, during your tenure as a GCEO and acting GCEO, you have acted the best interest of the organization?
Yes, with full confidence, I believe I acted in the interest of the organization.
My second last question. The chairperson put it succinctly that Mr. Mambo was still seized with the decision whether or not to approve the request that was made to him. Now, it appeared that later on, many years thereafter, when Mr. Mambo gave testimony in this commission, that he declined to approve the request that was submitted by Ms. Mahlalela because it did not make business sense. Did Mr. Mambo ever mention to you of that reason?
Never. But when I was doing my consultations with the SC, I did mention that we never had a discussion with Mr. Mambo. He never mentioned it.
What do you make of the fact that Mr. Mambo came to this commission and gave a reason he never gave before?
Mr. Mambo said a lot of things which I would take personally, but as a matured individual, I should not. I think Mr. Mambo, to me, he is not grounded, especially though he has some time in the SCM environment, but in terms of posturing or presenting himself to the company, because I don't think he has managed that skill to be able to posture himself, because he has a lot of experience in that. I cannot deny that. But posturing himself into playing that role, I'll give you, for instance, if you allow me to. When I was in marketing, you have to have a certain personality. You cannot have a personality which makes people, when they see you, they feel repugnant, as if they don't want to talk to you. You must be a person whereby from somebody who, from the lower ranks to up to very high places in government, they will very much like to have a conversation with you. But I think Mr. Mambo has not managed that skill as yet. I might be wrong.
Okay.
That's my view.
My last question.
Well, you said 2 and you did 3, now you want to do a 4th one.
That is the last one. Were you a Gupta acolyte?
A Gupta what?
A Gupta associate?
No. But the company that I worked with, the individual, Mr. Essa, was very much associated with the Guptas.
Yeah.
Yes.
Thank you, sir.
Okay.
Yeah.
Thank you.
Thank you, sir.
We are going to then adjourn. Thank you very much, Mr. Ntshepe. You are now released.
Thank you.
Thank you. It's 19 minutes to 2. We're going to resume at 22:03.
As you please.
We adjourn.